Court First Department. Hear, all persons having business with the Appellate Division. Come here, give your attendance, and you shall be heard. Please be seated.
So good afternoon, everyone. Welcome to the Appellate Division First Department. Our arguments for today, November 9. So this sheet says that there are 6.5 hours of argument requested. So that would be like 8 o'clock, right? So not happening, okay? Especially, it's going to be dark at 4, so it's definitely not happening. So please keep in mind we have read your briefs. We are fully familiar with your arguments. So please, just ask for the time that you actually believe that you need to get out your salient points. Not the entire argument that you've put in your briefs. Salient points, okay? Please. People v. Burris. Excellent. Submitted. Compass Concierge versus 142 Duane Realty. Submitted. Matter of Alicia H. Submitted. This is good. New York City Municipal versus Adams. Oh, okay. We're doing so well. Sorry, I'm only joking. Go ahead.
For the petitioner appellants, 7 and 3.
5, 2, and 5. Let's see. Arellana versus 386 Park Avenue.
Good afternoon. For plaintiff appellant 5 and 2, please.
Respondent 386.
Third party defendant respondent Lawrence Exterior 2.
5232. People v. Ruben Ramirez.
Good afternoon, Your Honor. For the appellant, 8 and 2.
Respondent
525.
5.
Axelrod versus 44 Lexington Association.
Defendant appellant 5 and 2.
Plaintiff respondent 6 and 8, 6 and 2.
Defendant, respondent,
5, 2, 5, 5 and 2, 5 and 2, 5. Bangladesh Bank versus Rizal Commercial.
Hi, Your Honor. Eamon Joyce on behalf of the RCBC defendants. May I have 8 and 2?
John Howley for appellant Campson Yon. May I have 3 and 1, please?
Jesse Loeffler, respondent, Bangladesh Bank, 5.
7, 2, 3, 1, and 5. What's that? OG versus the City of New York.
Plaintiff appellant 7 2. Respondent 6, Your Honor.
5, 2, 5. People v. Corey Jimenez.
Appellant 6 and 2.
5, 2, 5. Hutcher versus Madison Square Garden.
For appellant 8, that's Commissioner.
Do you see a respondent?
I don't see a respondent.
I-
So I'll take less if you don't have.
Do you want any time?
No, Your Honor, I'm fine with it, but
I mean, no, seriously, do you want to submit? We're kind of familiar with your briefs in all of these cases, but if you would like to argue something,
I'd like to have the chance to.
the new season, the prospects for the Knicks in the new season, you want to?
I will address any questions Your Honor has.
I do have questions in terms of where we're going, but in terms of the Knicks. But okay, why don't we just do 5 minutes? How about that? You're quite welcome. Patelli versus McGillivray. Mess that up.
Plaintiff's appellant request 7 and 2.
Respondent Magalia grade 5.
Respondent Trails 5 minutes.
5, 2, 5, 5. Durst Pyramid versus Silver Cinemas.
Respondent 4.
514. PC-16 DOE versus Hill Regional.
Appellant 8 and 2, please.
Good afternoon, Your Honor. Respondent 6 minutes.
626. People versus Pagan. 525. Wagner versus New York City Department of Education.
Respondent for, Your Honor.
424. Zhang versus the City of New York is I'm sorry. I don't have any time requested. Did I do that wrong? Yes, I did. Yes, I'm sorry. 524. D2D Holdings versus Bridge Market Association. That matter is submitted. So again, this is the time that has been allotted. If we have additional questions, we will certainly go over the allotted time. The first case for argument is New York City Municipal versus Adams. You may proceed.
May it please the court, Dina Kolker, Stricken Levan, for petitioners, appellants, the New York City Municipal Labor Committee, and various of the city unions that are members of that organization. It matters. It matters whether a policy imposed upon employees is issued by the government employer as employer or issued by the government as sovereign, utilizing its police power within its agency jurisdiction. It matters. And the reason, the fundamental reason why it matters is because employer policies, expressions of managerial prerogative.
So when was this petition filed?
The petition was filed in October of 2022.
And when did the mandate become effective?
The initial mandates became effective the prior year in 2021, but in September of 2022, the city reconsidered its mandates and changed the landscape of the mandates, rescinding all restrictions and requirements, including the private sector vaccine mandate effective November 1st, leaving only the public sector mandate in effect.
So you filed the petition was commenced in October 2022. The repeal of the vaccination mandate was November 2022.
It was announced in September to
Did not become effective until
November 1st, yes, the private sector.
Okay, so the effective date is November 1, 2022.
Correct.
You filed a month prior. So why is the litigation ripe?
Because
You filed before the repeal became effective.
yes, Your Honor, we filed seeking declaratory relief and to enjoin the city from rescinding just the private sector mandate and retaining the public sector mandate as of November 1st.
I guess the question is, you did that based upon a press conference, anticipatory. It wasn't something that had become effective yet. It was something that was announced that was going to be effective. So how then is it ripe for review by the court?
For declaratory relief, it's sufficient that it's not required that the harm has occurred already in order to bring a proceeding for declaratory relief where the government has stated and put into effect its action that will take effect at a particular time. The first part of the announcement actually did take effect immediately in September, which was rescindment of certain of the restrictions to do with activities at the DOE, and part of that same action involved the planned rescindment of the private sector mandate on November 1st. We sought declaratory relief before that occurred so that we could have clarity as to the legality of the sole remaining mandate being effective for public sector employees before it occurred.
And then the mandate was rescinded in February of 2023, is that correct?
Yes, the last mandate was ultimately rescinded in February
So
2023.
why is the proceeding not now moot?
Because, Your Honor, the relationship between the parties over this very important issue of what is the authority of the city to circumvent the collective bargaining process and single out its employees for actions that fall within the agency's police power is something that is going to recur.
Well, that's the
Whether-
question, because when you look at the mootness doctrine, the question is whether or not this is something that is likely to reoccur. That's
Yes.
one of the issues, right? So is it likely to reoccur that there will be a mandated COVID vaccination?
It is possible that there will be a mandated COVID vaccination, but the doctrine
is?
doesn't require that it be exactly the same situation. It requires that the situation that raises this issue will reoccur. And a health emergency, a communicable disease emergency, or other public emergency that involves the city agencies exercising their authority to require things of their public employees will recur. And while council has stated in the papers that COVID's over, it's never going to happen again, the reality is that the CDC and the state are actively planning, and the city, for the next health emergency in New York. It's not a question of will another emergency occur, it's a question of when and what it will specifically entail.
So that's exactly the point, right? That this particular emergency, the last pandemic was in 1918. Now we've had one in 2022. So the idea that every 100 years we might have to require people to be vaccinated seems to me like not one of those general things that is going to recur on a basis where we should be issuing proclamations about it now.
I see my time is up. May I answer the
Sure.
question? I think that looking at it as a specific vaccine requirement.
Well, that's what it is. That's what you're arguing, right?
No, we are, but we're arguing that the real problem here is that the city is having one of its agencies exercise its agency authority to implement managerial prerogatives.
Yeah, but we don't know what the next managerial prerogative is, and you want us to say generally that that the city can never do that?
The agency has to reach its determination within its statutory jurisdiction.
Right. So
Not
again, do you
simply
want us to make a
limited.
general proclamation that the city may not do that?
To balance the authorities between employer and agency, yes.
Ever,
Because
under
the
any
next emergency,
circumstance.
they will look to all of the cases.
Under any circumstance.
Under COVID.
Under any circumstance. You want us to say that the city does not have the ability to put forth these mandates?
No, that is not our argument. The argument
Then
is
you are
that
talking about the vaccine. You don't want the city to be able to reintroduce a vaccine mandate.
we don't want the city to be able to adopt a policy using its police power that solely applies to its employees, solely on the basis that they're its employees, as opposed to some reason within the purview of the agency's mission.
But how could we make a determination about that general proposition without a specific police power exercise? So the only one we have here is a vaccine mandate.
Correct, and in the next emergency, people will be looking to the decision below as authority that the fact that they're public employees is enough to exercise these other authorities.
So let me just see, but make sure I understand, because I see your time is up. But so you're not necessarily arguing the action, you're just arguing their authority and what they're able to do, regardless of whatever action it is, that they're limited based upon your argument to be restricted to the statute, regardless of any emergency, regardless of any other issue that's going on in the public. They don't have the authority to move and adjust going on in the public. They don't have the authority to move and adjust and react to that?
We don't argue that they don't have a right to move or adjust or react, but the sole basis for leaving this mandate, not personnel policy in place, that was provided is they're public employees. There was no reason given that's within the purview of the health department, right? They said, we left it there because we can, because we as an employer wanted to, and because there are employees, we control them. That is not an appropriate basis for an agency action. That is an appropriate basis for employer policy action, which is subject to
I thought there
different
was
restrictions.
more than that, though, but, you know, we could address that on rebuttal.
Good afternoon, Your Honors, and may it please the Court, Amy McCampbell on behalf of the municipal respondents. Your Honors, this appeal fails at the threshold for multiple reasons. I think most obviously mootness. The
Let me
vaccination.
ask you, what do you think about the ripeness? Was it ripe when it was commenced?
You know, Your Honor, we did not argue ripeness in this case, but I do agree that there are a lot of timing issues that plaintiffs have with this case.
So you're not, you don't think, you think when the action was commenced, it was ripe for determination, even though the new mandate was not going to be effective for another month?
The private requirement would be lifted a few weeks after they
Right.
brought the.
So that's why I'm asking you, do you agree that the action was ripe?
Again, that's not something that we argued before, but I agree that there are lots of timing problems here. There's a mootness problem. There's nothing to enjoin because there's no longer any vaccination requirement. And any declaratory.
But the argument, I thought, was that in the future, there may be a vaccine mandate, and that mandate may then affect the city employees.
That would be a hypothetical situation, Your Honor, and this court doesn't have the power to grant advisory opinions on speculative scenarios. Courts have held time and again that challenges to defunct COVID-19 measures are moot. And
But the argument is that you've gone beyond, or at least the city went beyond its authority to issue these mandates, these vaccine mandates to the city employees.
And the challenge to this particular measure, again, is moot because it's no longer in effect, and the declaratory relief that petitioners are seeking, it will not affect the rights of the parties. Petitioners also have a problem with res judicata because this is the third challenge that they've brought to this vaccination requirement. And they have never articulated their claims challenging this distinction between the public and private employee vaccination requirement until this third bite at the apple. So their claims are.
Let me just ask you, why doesn't it affect the rights of the parties being public employees? Why wouldn't this continue? Right? It's really about the city and how they interact or treat their public employees. Why isn't that always an issue?
So regardless of whatever this court declares about the validity of the requirement when it was in effect, it has no bearing going forward because the requirement was lifted in February 2023.
But the argument is that you could look back and say, well, this was in place, it was found to be valid or permissible, so therefore any subsequent vaccine mandate would also be valid and would also be valid.
Well, again, Your Honor, when the COVID-19 measure had been lifted, and courts have again held time and again that these challenges are moot when the measures are no longer in effect and there's no longer any effective relief that the courts can grant that would affect the parties. There's also, again, the res judicata problem and the statute of limitations problem, because when the petitioners brought this lawsuit, the vaccination requirement had been in effect for well over a year, and the terminations had occurred about 9 or 10 months prior to their lawsuit. So they're challenging the continued existence of the municipal employee vaccination requirement, and that is not a government action that is subject to Article 78 review. That's merely the continuation of the status quo. And as for the merits, the one merits-based argument that petitioners raised today is their claim that the city needs to go through collective bargaining. That's a claim that they already brought to the Board of Collective Bargaining, who resolved that claim. And they have not appealed that Board of Collective Bargaining decision. That is a claim that's not before this court. And I'm happy to address any other merits issues that if the court has questions on them, but we think that this appeal is an easy one on mootness, res judicata, and statute of limitations grounds.
Thank you.
Thank you.
Your Honors, we're not bringing a collective bargaining claim, but collective bargaining is the reason why it matters under what authority the mandate is issued. What the proceeding held was that because it was a health order issued by the health department and not an employer action, the order itself was outside of collective bargaining, only implementation. That doesn't mean all vaccine mandates, however imposed, are outside of collective bargaining. That means that actions of the health department in the public interest are outside of collective bargaining, not actions of the employer. The point that this case and the decision below, relying on arguments, reasoning, and facts outside of the record, in addition to its incorrect analysis, is going to be the precedent that people look to in the next emergency. And the city and state declare various emergencies all of the time. Emergencies have recently been declared to do with the immigration crisis. as well as other crises. So emergencies are declared all of the time. They're going to be looking to this decision below as authority to do something, and it will not have benefited from review by this court. Now, at least one of the cases that respondents have cited to that admittedly did say that they were not inclined to invoke the exception to mootness, that court, in order to maintain clarity and to avoid the lower court decision, which is unreviewable because of mootness affecting future decision-making, actually took it upon itself to vacate the judgment below because it was unreviewable on mootness grounds. The situation that we think would be the worst situation is if the decision below is retained, authorizing people to take actions they should not in the future, and there is no meaningful review at this level, which is why we believe the exception to mootness applies. But even if this court believes that the action is moot at this moment in time, we would ask that the court remove the incorrect precedent that was unreviewable.
Thank you.
Thank you.
Orellana versus 386 Park Avenue South.
Good afternoon. May it please the court. I'm Denise Rubin of Subin Associates, representing Augusto Orellano, the plaintiff appellant in this matter. As the court is aware, this was originally a motion brought on by the premises owner in a labor law case to dismiss under 3211A7, claiming that we had not made out a cause of
So
action.
what did you present?
I'm sorry?
What did you present? What evidence did you present?
We presented on a cross motion for summary judgment, the plaintiff's own affidavit describing the circumstances of his accident, how it occurred, that he slipped on a slippery.
In his affidavit, he said that he slipped on a greasy substance, but prior to that, the bill of particulars in the complaint alleged construction debris. Is that any reason to deny? Maybe there's a credibility issue there?
No, because that was a bill of particulars, which is not an evidentiary instrument. It's not evidence. And
Wait.
pardon?
Doesn't he review the bill of particulars?
He does,
And doesn't he say that it is true to the best of his knowledge?
he does.
So then he
Assuming
says
he was
that.
in the same county. I don't know. I haven't.
Well, generally, isn't that how it goes, right? Aren't you supposed to?
Generally, if the plaintiff does not live in the county where the attorney maintains their office, then an attorney verifies that.
And the
document.
attorney speaks to the plaintiff and says,
Yes.
is this correct?
Yes,
right?
but I would
So
argue.
that is a statement that would lead to inconsistency,
I
correct?
disagree respectfully, Judge.
Of course, that's okay.
Well, if I could explain why I disagree, I don't think construction debris does not necessarily mean something utterly different than a greasy, wet substance, slippery substance.
In the statute, it does. In fact, there are two specific subsections, one for debris and one for slippery substances.
I understand, but we're talking about what the plaintiff has described. He described that there was not only this greasy, slippery substance on the floor as he approached the cement mixer, but that there was some kind of debris on top of that, which, when the picture was taken, was no longer there.
So did he say when the picture was taken?
I don't know that he took the picture.
Do we know who took the picture?
I personally do not.
Well, let me put it a better way.
Let me.
Is there anything in the
Whoa,
record that
one
would
second.
indicate when the picture was taken?
I'm sorry, say
Is
again?
there anything in the record that would indicate when the picture was taken?
I don't believe there is.
Is there anything in the record that would indicate who took the picture?
I don't believe there is.
So the picture is essentially unauthenticated, except the plaintiff says this is what it looks like. Other than that, it's unauthenticated, correct?
Understood.
Mhm.
But his affidavit.
No, it's not understood. Is that correct? Is what she just, is that not what the record indicates?
The record,
The record indicates that
Right.
these photos are unauthenticated. The plaintiff could not attest to or state who took the photographs. He was unclear as to when the photographs were taken as well. Is that
I don't know that he couldn't state or that he was unclear. I don't know that he was
Is there
asked.
anything in the record wherein he states?
No.
Okay.
No, he did not state it in his affidavit.
So
and
we
that
have an
is-
affidavit which you argue that it doesn't, but it does conflict with the bill of particulars. We have unauthenticated photographs. So why, therefore, would the motion for summary judgment be granted?
Because nothing was offered that is in admissible, credible form to rebut his statements under oath in that affidavit. Nothing. Not one word by a person with knowledge.
So let me ask you, isn't the person who he says employed him put in information denying that employment?
Only the fact of the employment. That
Right.
doesn't deny the fact that he was there, that he was working, or that he was injured.
Okay, but no depositions have taken place, right? Is all document discovery has been exchanged?
They've had 2 years to take a deposition, Judge. They didn't do it. And it is their job site, it is their premises. It is reasonable to assume that facing a summary judgment motion with an affidavit signed by a guy who says, I was hurt on your premises, that they might talk to, their supervisor or their project director or the GC. It does not appear that they did any of that. They
Except
simply
it's
came
your burden on summary judgment, right? You have to,
Which the
your
affidavit-
burden, your burden.
Respectfully, Judge, that affidavit meets the burden. It states factually under oath what he recalls and what occurred. I see my time is up. Thank you.
Thank you.
May it please the court, Jonathan Wajo from Romano Benowitz for 386 Park.
You represent whom?
386 Park.
So that your adversary brings up a point. What did you put in opposition to summary judgment?
Well, the problem here, Your Honor, is that if you take a look at the photographs, it could be any of thousands of construction sites.
Normally, when one opposes summary judgment, one puts in information and affidavits, which you didn't do, right?
Correct.
Why not?
Because the plaintiff's affidavit does not identify where on the premises this accident took place. It's either in the complaint or in the bill of particulars says something about the sidewalk.
Did you do an investigation?
I'm sure they do. I don't know personally what
Yes, of course.
investigation.
I'm speaking of the royal you. Not the, did your client do an investigation?
I believe so.
And
But
where
the
is-
problem is they can't identify this site because if you look at the photograph.
Yeah, but I mean, at a minimum, you could have put in an affidavit that says we don't have any an accident report or any information about this accident. Even that you didn't put in.
That's true. What we were looking for is the deposition of the plaintiff who could tell us
Okay.
where the accident
Fair enough. Okay.
occurred.
Okay.
The other thing is that, the affidavit from the employer saying that this guy was not his employee after the plaintiff himself said in a sworn statement, I was employed by this outfit. I think that creates a question of fact on its own. And even though in reply, the plaintiff said, well, you should have brought that up, the plaintiff's own papers recognize this problem of employee. If you look at page 300 of the record, they try to pass it off as it was the defendant's burden to show that he was not employed at the site. But this is, some laborer who said he was employed by this guy, and as far as we know, he wasn't. So that's at least a question of fact. Thank you, Your Honor.
May it please the court, Leslie Luke from Black Marjorie Sanford on behalf of third-party defendant and respondent Lawrence Exterior.
So your client claims that the plaintiff never worked for you?
Correct. In his affidavit, which is the entire basis for his claimed entitlement to summary judgment, Plaintiff alleges that he was a Lawrence employee. Plaintiff then claims that he was walking down a passageway carrying cement bags to a mixer when he slipped on debris that was on top of a wet and greasy substance. Plaintiff's cross motion for summary judgment was properly denied for two reasons. It's premature, despite the claim that we've had.
So again, so your president, Brad Coleman, says plaintiff was not employed and never had been an employee of Lawrence on or prior to the day of the accident.
Correct, Your Honor. What is there for me to investigate at this time? As we sit here today, we still have no idea where plaintiff is claiming that the incident occurred at this premises. Did it occur inside? Did it occur outside? And even in the affidavit, there's vague mention as to
But
what
couldn't there have been an affidavit from someone saying, well, I worked there that day, I was supervisor, and no accidents occurred anywhere? I mean,
the fact is that the motion was made prematurely because I haven't had the opportunity through pretrial discovery to depose plaintiff, to get the necessary documents in order to defend plaintiff's claims.
When did you get the photographs?
I'm sorry?
When did you get those photographs?
The photographs were next to the motion.
Oh, you didn't get them before the motion?
I had not seen any papers prior to.
So you're saying the first time you saw those two photographs was in
The first time I saw those photographs was at the time that the
Plaintiff
motion was made.
Okay.
Even, there is no context for these photographs. Plaintiff is hanging his hat on his self-serving affidavit and the two photographs, ignoring, even assuming that plaintiff's motion is not premature, which it clearly is because plaintiff isn't even scheduled to be deposed until February 15th of 2024. Plaintiff has not met his burden. That's not my job. Plaintiff made a cross motion for summary judgment. He claims entitlement to summary judgment on 241-6 based on a claim violation of 23-1.7D. Based, again, solely on the affidavit in which he solely identifies this location as being a passageway. The photographs themselves seemingly showed two different locations. The affidavit itself doesn't say where this purported passageway is in relation to the premises, where it led to, where it was coming from, when he entered, where he was coming from, whether—
Thank you, counsel.
I'm sorry, Your Honor. Thank you.
Thank you.
Okay, let me start by saying, as this court is of course aware, you can't decide a motion for summary judgment on credibility. So if the only problem with that affidavit is that it seems incredible because it doesn't match up word for word with the bill of particulars, credibility is not a basis to deny summary judgment. An affidavit—
Counsel, your client said he works for Lawrence and he got injured, correct?
Labor law clients make that mistake every day of the week.
But is it an issue of fact, counsel? Lawrence is
Not
saying
as
we've
to
never
his
employed—
claim. He has no claim against Lawrence, Judge.
But Lawrence said we never employed him, ever, ever. We don't know this guy. Isn't that an issue of fact? How is it
No.
a slam dunk
I mean,
summary judgment?
it's not an issue of fact in the sense that he has no claim against Lawrence.
No, but he has to be a construction worker. He can't be, how do we know that he didn't walk in off the street? He has to be working at that construction site to get the benefit of the labor
I
law,
understand.
correct?
Judge—
So if the employer says he wasn't my employee and he doesn't know, I mean, ultimately, maybe it will turn out, but—
No, Judge, if I may, I have information that is not in the record. I hesitate to offer it because it's towards the record.
Exactly. So we can't consider it. So on the record that we have statements that he was not an employee of Lawrence. So there's a question as to whether he is even a worker and therefore it falls under the labor law. And then we also have the issue in terms of his affidavit and the unauthenticated photographs. We don't know where the accident allegedly occurred.
It occurred at 386 Park Avenue South.
Where? I think 386 Park Avenue
On a
South, maybe a
scaffolding.
large, excuse me,
I'm sorry?
maybe a large building. I'm thinking it's not like, one floor, right? So
Understood.
where in 386 Park Avenue South did it occur?
That is not relevant to whether he has a cause of action under Labor Law 241-6.
Let me just ask you one last question. When did you exchange those photographs?
Judge, I'm stepping in for an attorney whose mother died this
I'm
week.
sorry. So
I
again,
just
I'm
don't know
using the
this record
royal
with
you.
that kind of.
I'm using the royal you again. I'm saying, when did your
Again,
client?
I would love to
don't-
answer
you
you,
don't
but
know?
I stepped
Okay.
in on very short notice, so.
Thank you. Thank you all.
Thank you, Judge.
People v. Ruben Ramirez.
Good afternoon, Your Honor, Your Honors. This is David Richards representing the appellant from Kramer 11, Appellate and Frankel, serving as co-counsel of the Legal Aid Society. As you know, this is an appeal of the first conviction of my client, the appellant Ruben Ramirez, on first-degree assault, as well as an appeal of the sentence for 9 years, seeking the mandatory minimum of 40. Just to give some background here, I would like to provide a very brief upshot of the background of this case and then proceed to the arguments regarding the hearsay.
So as you can do it in now 4 minutes and 22
Okay,
seconds.
understood. Just at the outset here, the appellant was convicted of this first-degree assault offense. It was undisputed that
Well,
my
counsel,
client
we
stabbed.
read the briefs. Why don't you just proceed to the argument?
Okay, understood. But I want to just reiterate, it's undisputed that my client stabbed the complainant.
Yeah, we've also watched the video.
Okay, yes.
So
Okay,
we watched
understood.
the video, we watched the stabbing.
Understood.
We saw everything.
Okay, very good. On the medical issue, I want to reiterate, just this was a he said, she said issue. The evidence here was very close in terms of whether my client was stabbed. That was the only question that was presented in this case, was the timing when my client was stabbed.
So the medical records, the court did not allow or redacted the medical records as to certain statements made by your client as
Correct.
to where he was stabbed, right?
Correct. Confirming that he was stabbed by a blade on the bus. And this was the only form of corroboration that we had on this record. Again, a very tight record on the question of when my client was stabbed and whether he was stabbed by the complainant, which was the entire defense in this case. This was the only form of documentary corroboration. The only other corroboration there was that was relatively contemporaneous to the event was my client's statements to police officers that he had been stabbed.
So was it that the defendant was contemplating a justification defense?
I'm sorry, I didn't know.
Was it that the defendant was contemplating a justification defense?
Was it that he did present a justification defense?
So what was the issue then?
In terms of the hearsay statements?
Yeah.
The issue here is that these were the only statements that supported the defense's position of him being stabbed on the bus.
It was
Otherwise,
his
just
statement. It wasn't corroborating. It was his.
Right. It was his. This is a
It was
corroboration.
bolstering. Yes, I said it, and yes, it's true, right?
Certainly, but the difference, I think what's important about these statements is outside of this, there is no other statement that my client made to anyone on the record.
Is the statement that maybe you're focusing on the part of the statement that would be that he got slashed with a blade, or are you focusing on the entire statement that he got into a fight on the bus and then was slashed with a blade?
That he was slashed with a blade on the bus.
Okay, but how does that bolster your defense?
It bolsters the defense because outside of this, there is no other corroboration that my client said anything contemporaneously about being stabbed on the bus.
What did the medical records show? Did the medical records show any slashing or any laceration or anything?
They show a laceration, but they don't show when it happened. And this statement was important to that. Otherwise, we have no corroboration. There's nothing else on the record
Would the
here.
video, if it showed such a thing, corroborate that?
The video is inconclusive as to whether my client was stabbed. What we see on the video is the
But the
complainant.
jury had the opportunity to view the video?
Certainly they did, but they also were presented with these medical records that showed no statements corroborating my client's account in his record.
But really, honestly, the only thing that could have helped for medical treatment was that I got slashed on the leg. On the bus has nothing to do with the medical treatment. So the only
Certainly.
statement that could have come in,
That's fine.
which is I was slashed on the leg, doesn't help your client because it doesn't say where he was slashed. And so that's
The location, where the slashing
That's
took
not
place.
helpful to
I take the point and I understand the point there, but I want to point out the complainant statements came in, and I'm not arguing that the complainant statements should not have come in, materially identical statements. I'm not arguing that they should not have come in, but the fact that they came in and my clients did not was prejudicial to the jury because now the jury
How is
sees
it prejudicial to the jury? The jury watched the
prejudicial
video.
to my client.
The jury watched the video. The jury heard your client's testimony. the jury viewed the hospital records subject to the redaction, and then the jury made a determination.
Certainly, and the jury saw no statements by my client in his medical records saying that he had been stabbed, anything but corroborating his story in the medical records.
Would the jury know that there are going to be statements made by your client to medical personnel as to what occurred?
Yes, because they saw them in the complainant's records. His own statements to that effect to medical personnel were in the complainant's records, but not in my client's, because they were redacted erroneously. That's the unfairness in the dichotomy.
No, but you keep saying erroneously. The only thing that could have fallen under the exception to the hearsay rule under the medical records is I was slashed. And if you're saying I was slashed, how is that helping your client? Again, that's the only thing that could have come in.
Is that he was slashed and that he was punched 4 times as well.
No, he didn't seek any treatment for being punched. He sought treatment for being slashed. That was the only thing that could have come in. So again, I ask you, how would that have changed the outcome of this case?
The fact that he was slashed, the act of being slashed implies that someone else slashed you, I would argue. And I think it's consistent with what he said. It corroborates his account in a contemporaneous way. And there is nothing else here. The only other statement that even comes close to corroborating any contemporaneous statement by him about his account of what happened is that he told police officers. But that's consistent with the government's narrative, which was that he made this up to get out of trouble by telling authorities. This is the only piece of evidence that...
Was that argued by the people that he made this whole thing up?
I'm sorry?
Was that argued by the people that this was somehow fabricated by the defendant?
Completely, yes.
That the slashing was fabricated?
That he slashed himself after the fact. That was the whole story here. That's the whole question.
But you do see that that would not have been admissible in terms of treatment, the fact that he got slashed on the bus. His statement was, I got into a fight on the bus and got slashed with a blade. The only thing that would have been admissible is got slashed with a blade, not that he was on the bus.
Correct, but the being slashed with a blade implies that someone else slashed you, I would argue. And if read, it implies someone else slashed you. It doesn't imply that he slashed himself.
Okay, you have time on rebuttal.
May I just have one word on the excessive sentence point, just a sentence?
Sure, on rebuttal.
Sure, okay, understood.
Thank you.
Thank you.
May it please the court, Maria Wager for the Bronx District Attorney's Office. Defendant wasn't convicted because of any error by the court or misconduct by the prosecution. He was convicted because, as your honors pointed out, his crime is on video.
Well, I guess counsel's argument is that the the complainant's statement to medical personnel was able to be put before the jury, but the defendant's statements to medical personnel was not put before the jury, and then the people were able to argue on summation recent fabrication or that he slashed himself, and so therefore it was prejudicial to the defendant.
Your Honor, what happened was the people had put the victim's medical records into evidence, and as the court pointed out, it was an oversight for the people not to ask for redactions. What did not get redacted, the hearsay in the victim's records, actually hurt the people. And it's in the record that defendant, when the people pointed out, wait a minute, those need to be redacted before they go to the jury, the defense said, whoa, wait a minute, nobody asked for redactions, and the court, noting it was probably an oversight by the people, said he's right, they're already in evidence. The hearsay in there was the complainant's mother pointing out that, maybe her son needs anger management and this kind of statements, which defense used at trial and he's using on appeal. Nobody here disputes that there was a fight on the bus. That was never in dispute by any party. All that's in dispute was, as your honors pointed out, is when did defendant get slashed? He wanted the jury, he wants this prior consistent statement that it happened on the bus. And whether defendant got slashed on the bus, off the bus, is not relevant to his treatment or his diagnosis. And he's just trying to get it to bolster his defense. And I disagree that there's no other evidence. There is a police officer body cam footage of the defendant surrendering with a bandage on his leg. There's also testimony from the officer, while he never mentioned his injury on the phone call, he did mention it when he came to surrender. That's the first time he brings it up. So there was other evidence. So the people's theory, however, because in the footage, there is no sign of the defendant being slashed. The people asked the jury to draw a reasonable inference based on the evidence that this was self-inflicted. When defendant knew he had to surrender and he was desperate, his girlfriend is at the scene with the police officers.
And so
they know who he is.
what you're saying is that the only part of the medical record that was arguably not admitted improperly wouldn't have helped him in that way anyway, because it was on the leg, which would not, on the bus, which wasn't directed towards medical treatment.
That is correct,
Okay.
Your Honor. On the bus is the only piece of the statement that would have helped defendant. Nobody disputed he surrendered with a slash on his leg.
Did you wish to address the excessive sentence?
Your Honor, everything that defendant is bringing to this court, he brought to the trial court. And the trial court already shown mercy to the defendant in its sentence. And while a defendant certainly should not be punished by going to trial, it's called a plea bargain for a reason. That pre-trial offer is a bargain. So it should be expected that after trial, a sentence would be harsher. And here the court didn't do that. The court gave defendant what he was offered pre-trial, and it's based on his medical condition, his criminal record being very remote, and so forth. And all these things also did not prevent the defendant from plunging a knife into a 14-year-old teenager over a slight on a bus. So his medical condition and his age, those were all pretty much the same back then. So there's no reason to show him any more mercy than he's already been shown. If there's no other questions, thank you.
Your Honors, one point in rebuttal on the other corroborating evidence here of my client's account that he had been stabbed on the bus. Note again that his body cam footage of his statements to police officers. That is completely consistent with the government's theory that he made this up to get out of trouble with authorities. This is the only piece of evidence that didn't come directly from his mouth. It's documentary, it's separated from him. It wasn't just purely testimonial that showed and corroborated that contemporaneous with this, he was telling people besides authorities of the same account. And yes, it's the fact that he had been slashed. That implies a third person. You don't say, I got slashed when you cut yourself. You say you got slashed by someone else. That's important. It was germane to treatment. Second, just to point out again, the government's theory here and how they created pushed this false insinuation of self-infliction in the justification defense. They knew from the outset that Mr. Ramirez had told officers that the knife they found was his, but that statement was suppressed. He said that at the time. They knew that from the beginning, that he admitted the knife found at the scene was his. They go on to summation. In summation, they argued, Mr. Ramirez wasn't counting on the fact this is why he admitted that the knife was his, according to the people on trial. They weren't counting on the fact that when they found his knife, there was still a little bit of blood right there. There was no way Mr. Ramirez could deny this, so of course he's going to come up here and say, oh yes, that's the knife, because you cannot deny DNA. This is the same knife that he admitted, they knew he admitted to having and admitted it was his. Without DNA evidence, they knew that immediately. They created, this is an argument that's based on recent fabrication. It was knowingly false, and it was designed specifically to support this argument that he self-inflicted a wound. That was the entire case, okay? So you've got a failure an error that prevents corroboration at trial, evidentiary. Summation backs this up with another improper argument that is knowingly false insinuation.
You don't think that after watching the video that the prosecution could credibly argue that he didn't stab himself on the bus?
I don't think that the video shows.
Okay.
I do not believe that. Look at if the video shows, first off, the complainant initiated the physical altercation, right? So in any event, on excessive sentence, this is at worst a matter of improper self-defense or imperfect self-defense, right? What we see on the video is the complainant physically attacking my client over and over and over again. My client is not responding. My client is not engaging. Remember, he has a knife in his pocket from work the whole time and doesn't take it out. He's not reacting until, consistent with what my client testified, we see the complainant duck down below his legs into where this injury occurred. My client doesn't know where the video is on the bus. He doesn't know where the camera is. Why would he make this up? It's exactly where he goes. His hands are free, and we know as soon as he pops back up, the complainant, that's when he stabs him. That's what we see. That's what the video shows. It is consistent with my client's narrative.
Thank you. Thank you both.
Thank you, Your Honor.
Axelrod versus 44 Lexington Association.
Good afternoon. May it please the court, my name is Lauren Donnelly, and I represent Transition Management Corp. In this case.
Counsel, I just want to draw your attention to record at 899, the standard staffing addendum, because I think this is where it's going to create maybe it might create a problem.
I'm sorry, I didn't hear that.
899.
899.
The standard staffing addendum, where it says that all services will be performed in accordance with good and workmanlike manner and in accordance with the highest industry standards. So if we were to agree with you that, let me back up. What kind of liabilities does this particular statement impute to your client?
It doesn't impute any liability because if you look at the totality of the circumstances, setting aside that particular statement, you see that the transition did not direct, control, supervise, interview, train any of them.
But you started out by saying setting aside this particular statement. Can we set aside this particular statement?
Yes, you can, because the facts of this case conclusively establish that the maintenance workers were special employees of the hotel, and therefore the hotel is vicariously liable for.
So let's start with the proposition that finding a special employee is intensely factual, right? Can we agree on that? All of our law says that.
It is a fact, but it can be decided as a matter of law.
Intensely factual. And if you lined up the number of cases that were decided as a matter of law as opposed to a matter of fact, you would find it very unbalanced, right? So here you have documentary evidence that contradicts what your client is saying, right?
It does not necessarily contradict it, but I just want to point out initially that the court should be aware, and we mentioned this in our brief. There are some problems with the staffing addendum in and of itself. It was not fully executed. It was drafted by the hotel, and it refers to a contract that does not even exist. And
I mean, the record is what it is. We have what we have. Let me ask you this: Who did the general employer retain the right to fire workers?
Yes, but that's not determinative.
I agree, but we're talking about as a matter of law, right? When you say it's not determinative, that means that there's nothing on one side and you want it as a matter of law and everything on the other. In this case, the documents show that the general employer had the right to terminate, correct?
Yes.
The general employer had the right to discipline, correct? And hire, and pay.
Yes.
All of that.
Yes,
Does the staffing addendum also indicate that the hotel has the ability to terminate? Or is it just the
I'm
general?
sorry, I didn't hear.
Did the hotel retain any power to terminate, or is it just the general
I don't believe so. I think it was the transitions responsibility, but they didn't even exercise it. And in these, if you look at these cases, even though where there's this comprehensive direction, supervision, and control, even the right to hire and fire doesn't negate a special employee relationship. And the case one of those cited in our brief was Maldonado versus Canic International.
But counsel, so what then does the addendum mean? What is the meaning of it where it says that TMC guarantees the quality of the work performed by the engineers?
The quality of the work is not really been addressed. There's no evidence whatsoever that these
If they're
employees did anything.
if they're guaranteeing the quality of the work, does that not suggest that there is some type of review, supervision, et cetera, of the work? At least review of the work, if you're guaranteeing it?
There was the only entity, the person that reviewed their work and supervised their work, inspected their work, was the hotel.
Well, the hotel stated, Frank Watch, stated that they trained, scheduled, and oversaw all the engineers on staff and dealt directly with those engineers. Doesn't say that they disciplined the engineers, nor does it say that the hotel in any way guaranteed the quality of the work performed by the engineers. And I didn't see anything in the record that showed that TMC in any way gave that ability to the hotel, including the right to terminate.
There was no document that transfers that back to the hotel. However, the facts establish that that was turned over to the hotel.
Thank you.
Good afternoon, Your Honors. Jonathan Canuck, counsel for plaintiff respondent, Nicole Axelrod from Miller, Eisenman, and Canuck.
Counsel, does the conduct of the parties in how they acted in terms of the contract mean anything? I mean, yes, this contract, the staff in the addendum says that they guarantee the quality of work, but really, it was the hotel staff that was supervising, directing, scheduling, and all of that.
Your Honor, as counsel pointed out, this comes down to a totality situation. Here, the addendum on multiple points, not just what was discussed, but on the fact they would provide maintenance labor, pay its employees, track its employees' hours. Once again, as noted, all services will be performed in accordance with good and workmanlike manner and in accordance with the highest industry standards. That's an affirmative obligation that they took on and they added into this contract. So whether or not they did it, if they didn't want to oblige by what they agreed to, still, that's in the contract, and they were supposed to. So if they didn't supervise, if they didn't see the quality of their workers, that's on them, but they were still supposed to do that. In addition, at its sole expense, TMC was required to perform verification of work eligibility and criminal background checks on their employees before any assignment. Again, whether or not they did this, I don't think they did, but they were supposed to. That's another affirmative obligation that they entered into when they entered this contract with the hotel. They retained the sole right to terminate its employees. They retained the right to discipline its employees. They required securing workers' compensation insurance. And I think most importantly is one provision where both parties entered into and agreed upon in their business relationship. The parties here too agree that in performing their respective obligations under the agreement, vendor's relationship with hotel shall be that of an independent contractor. All personnel who provide services hereunder shall be considered employees of the vendor's employees, and shall not be considered employees for the hotel for any purpose. This is what they agreed to when they signed the staffing agreement. And as this court knows, it's a high burden to show a special employment situation, and normally it is a factual question. And they've offered no other affidavit or anything else that would support it, and I feel like that they have not met their burden on this particular issue.
Thank you.
May it please the court, Mitchell Cohen for the defendant Appellate Hotel defendants. I've listened to all the questions. I'm going to try to be brief. There's a general rule that all provisions of a contract should be given weight and not disregarded. The argument by Transition Management Corporation is ignore the entire contract. They have asked for summary judgment based upon their agreement that they breached the contract. There's not a judge or lawyer in this room, I suppose, who has ever seen that happen. Transition signed the addendum to be effective February 1st. They charged extra money. Record page 908 for a mobilization fee. The mobilization time period of 4 months computes to June 1st of 2015. On October 1, 4 months after the mobilization was to be completed, according to Transition, it had, quote, inherited employees. That is not a legal use of the word inherited. They breached their promises, their agreement. So unless there are any questions on that issue, I'd like to turn to the indemnification issue. The indemnification clause, if you look at the Transition brief, they argue two things. One, that the Lexington Brass was not part of the hotel. And in support, they put in the Lexington Brass lease, which states that the brass is to serve the hotel guests and provide room service. Usually when you go to a hotel, a meal is included. Times have gotten tougher. Now you pay for the meal. But that kitchen in that restaurant was part of the hotel. In addition, they argue that the indemnity is limited to Clause C, the provision of services to the hotel. I think even under that provision, their motion was properly denied. It's a close question whether the court should have granted indemnification to the hotel. But they gloss over, and it's not in their brief, subsection A, arising out of vendor's performance under the agreement. What needs to be said other than Transition did not perform under the agreement? They owe indemnification. Thank you, Your Honors.
Thank you.
Just a couple points. This is not a breach of contract claim. The issue here is whether the maintenance workers were a special employee of the hotel. And in terms of the contractual indemnification, you can't be indemnified for your own negligence. The hotel has not established that they were not negligent. So any award of contractual indemnification would be premature pending an apportionment of liability. For all the other reasons in my brief, we will rest on it. Thank you.
Thank you. Thank you all. Bangladesh Bank versus Rizal Commercial.
May it please the court. I'm Eamon Joyce, presenting argument on behalf of the RCBC defendants. The forum nonconvenience factors here track those in Bloomberry, and Supreme Court erred in reversing course. Nothing about Supreme Court's statement on record page 9 that analyzing the case with a focus on the theft changes the outcome now that the RCBC defendants are before the court. The decision below otherwise confirms as much, that the complexion of the case remains unchanged. If you look at record page 17, the court stated the theft of the funds did not begin with the hack, but with RCBC's opening of the fictitious accounts. But that occurred in the Philippines, just as these circumstances did when this case was last before you in Bloomberry. Indeed, Bangladesh Bank pleads that those accounts were created by and at the behest of Wong. That's at record 166, paragraph 89, in the Philippines, and goes on to plead at record 173, paragraph 115, that only the defendants could have passed along that fictitious account information, again, received in the Philippines, to the hackers. But those same circumstances were central in Bloomberry, with this court dismissing EHL, which Wong is the principal of, on forum nonconvenience grounds, while crediting the same set of allegations. Quote, Wong was involved in providing hackers with the requisite routing information concerning the fictitious accounts. All of this takes place in the Philippines. Moreover, the case doesn't...
Wait, you represent the bank?
The bank
and... The bank that has all the branches here in New York?
No branches here in New York, Your Honor. None at all.
Has correspondent banks here in New York, right?
It
so
has
the last time we were talking about the casino and the money laundering, right? The casino is in the Philippines, and the money laundering happened in the Philippines. That's completely different than the bank who has worldwide access, financial systems that go all over the place, electronic information that goes all over the place. So no, it's not the same, right?
I disagree, Your Honor.
Okay, tell me how whether it's casino employees in the Philippines are laundering money in the Philippines by changing chips and then at the end of the night creating cash is the same as your bank sending money through the international systems to correspondent banks in New York, all of it which must be documented electronically, unlike the casino workers, whether or not they're cashing in 1 million chips or not. How is that the same?
So let me start with the factual point. Our bank didn't send anything, right? Bangladesh...
Your correspondent banks, for which you are also, right?
Correspondent banks, which are not our client. That's that's Boney, that's Citibank, that's not RCBC. Then as to the...
Did RCBC send money through its correspondent banks?
No. What happened is Bangladesh Bank sent a fraudulent transfer order. Hackers sent a fraudulent
the other way around. Did Bangladesh send the money through the correspondent banks?
Yes, through the correspondent banks. But you have to think about what Bangladesh Bank sent. Bangladesh Bank sent payment instructions to go to a fictitious account. What we know about the fictitious account is the casino's principal, Mr. Wong, precisely the principal that led to the casino being dismissed, is equally linked. The only allegation is that the fictitious account number was used to send the money overseas. Wong had that. It was his account. He opened those accounts. The pleadings are undisputed on that. And the same pleading about the accounts being opened mentions both Wong and RCBC. That's at paragraph 89 of the complaint. And then it's at paragraph 115 of the complaint where plaintiff says only defendants could have passed along the fictitious account information. That's wrong, as any low-level employee could have passed along that information, but this court credited part of it and said Wong passed along that information.
Okay, so I'm not going to, let's move on, because I don't think we agree. Why don't we talk about individual personal jurisdiction?
Can I say one more point, Your Honor, on the last point I think to make is this is a conspiracy case. The laundering hasn't dropped out of the case. All those facts still need to be proven. When you look at the IAS court's opinion describing what it calls the highlights of the allegations against RCBC, they're all on pages 14 and 15, and they are all about things that happened in the Philippines. So I think you can't separate the theft from the laundering in a conspiracy case that presses both liability theories. As to personal jurisdiction...
But the theft can be a liability theory on its own, right? I mean, the theft allegedly happened, and then the money was laundered.
Correct, but the theft happened because of fraudulent payment instructions sent by North Korean hackers using information that was gained in the Philippines by setting up fictitious accounts.
So why does it matter when the funds are transferred out of your corresponding banks here in the United States through the Federal Reserve?
I don't think it matters, Your Honor. I think Masher Bank would have come out differently if that mattered. I mean, that's That's the same setup in Masher Bank, right? There's a fraud conducted through New York accounts. And Masher Bank, frankly, the money's in the New York accounts a lot longer. Plaintiff sends $150 million to a New York account to square up exchanges done on the Federal Reserve, currency swaps on the Federal Reserve. That $150 million sits in New York, is stolen from New York, goes to another New York correspondent bank account. From that New York correspondent bank account in Masher Bank, it's sent overseas. That's exactly what that case is about. And the Court of Appeals said, look at the factors. Don't look at Nexus alone and elevate Nexus simply because there are financial institutions involved. And when you look at these factors, they line up perfectly with those Masher Bank factors. But Judge Scarlett-Pula, I don't mean to ignore your question on personal jurisdiction.
No, that's fine.
So I'd like to get back there.
I mean, the fact of the matter is, right, form nons is discretionary. Personal jurisdiction is, right?
To an extent. What's interesting in Masher Bank, right, is the Court of Appeals found an error of law.
What are you arguing with jurisdiction?
So do you have a particular prong? Because
I mean,
personal jurisdiction, the reason we put FNC
let's start with 302A1.
So with A1, right, I think if your Honor's decision in Al-Rashid had carried the day.
Which it didn't. It didn't.
Right.
So I mean, we're all,
maybe
that's
we should
it.
ignore that.
So I think it would be easy if your decision prevailed there, but I think that just turns this into straightforward. This is not Al-Rashid, right? There are 12 transfers from Citi alone in that case.
But I would say that this is more than one transfer, right? And it's correspondent banks, and the Court of Appeals said in Rashad that because we have correspondent banks here in New York, and because that affects the New York banking system, which is probably the most robust in the world, maybe London would disagree, that's enough.
Yeah,
so, I mean,
but I don't think factually they're on par. I agree with Your Honor that there are multiple transfers, but they're in the blink of an eye, and they're not purposeful in the same way, right? Al-Rashid's got these transfers going through Citi, going through HSBC, going through Deutsche Bank, going through JPMC, all in New York. Here, you have 26 million go out the door at the same time through Pennsylvania. Nothing to do with New York.
Yeah, but you do have 60 million going through New York. Come on.
I understand. I agree, but it's a one-off. I think it's different than Al-Rashid, but I think FNC is the easier path to get there. If you want me to address A2.
You can do so on rebuttal.
Thank you.
May it please the court, John Howley for Appellant Kam Sin Wong. The causes of action alleged against Mr. Wong cannot be fairly adjudicated here in New York. All of his conduct is allegedly in the Philippines. All of the witnesses that are necessary to prove or disprove his liability are in the Philippines. None of those witnesses is subject to compulsory process. They can't be compelled to testify here. And there isn't a single witness anywhere in the United States, let alone New York, that is relevant to the allegations against Mr. Wong. The motion court did not address these facts. The motion court addressed the forum nonconvenience analysis with respect to RCBC, and then said Mr. Wong waived forum nonconvenience, and in any event, for the same reasons as RCBC, I deny forum nonconvenience dismissal. Well, Mr. Wong did not waive forum nonconvenience. He was not required to assert forum nonconvenience in his initial motion challenging service of process under the Hague Convention. That's pretty clear from 3211E and 327 of the CPLR. And as someone who has never been to the United States, it was reasonable for him to challenge the service first before getting into the forum nonconvenience. And as soon as the service motion was denied, he made the forum nonconvenience motion. He has not sought any benefits of a New York forum, and all of the cases cited by the court below and by Bangladesh Bank involve situations where the party who waived forum nonconvenience did not make the motion until after they took advantage of discovery practice and discovery motion practice and the assistance of the court here. None of that has happened here. In fact, last week the parties filed a proposed preliminary conference order that provides for a demand for bill of particulars or interrogatory answers to be served on March 29, 2024. So Mr. Wong has not done anything to take advantage of a New York forum. He cannot get a trial here that would be fair. And in fact, we run the risk that if there is a judgment against him because he can't get his witnesses here, that judgment would be unenforceable. Thank you.
Good afternoon, and may it please the court. Jesse Loeffler for Plaintiff Respondent, Bangladesh Bank. When we were last before this court with respect to the two casinos, the court was very focused on how do we tie those two to New York. These defendants are different. They are tied to New York through the creation of the fictitious accounts, and Judge Maisley makes clear that she understands that distinction and the theft. She says in the first sentence of her opinion, while the prior motions were focused on the alleged money laundering aspect, these were focused on the theft itself in New York. This is a $100 million theft out of...
But isn't everything related? Ultimately, the purpose of this whole conspiracy was allegedly to get to the money laundering, to get the money. How do you separate it?
Right. So, again, I think Justice Maisley makes and they call it a hasty reversal of her position. Well, she took 9 months to write a 35-page decision, and she goes through all of the RCBC individual defendants, RCBC, Wong, and writes a detailed analysis. This court previously adopted her discretion with respect to the forum non, and we think you should as well here. With respect to how you divide it, at the time, our position was, the casinos are in the conspiracy, therefore they're in New York too. This court has ruled on that. Now we have Wong and RCBC. We could have brought a suit here without the casinos on a conversion theory because those defendants are the ones that exactly touched and reached into New York to steal $100 million. And it wasn't just $100 million. That's what they got. They tried to steal $1 billion. There were 70 payment orders that came through here, not a single one-off. So this was a massive theft out of New York, just down the street from the New York Fed. I like to joke that this is basically Die Hard 3, but with digital theft. Looking into the facts of how these defendants reached into New York, again, I think I heard that, oh, well, this was all Wong. Well, that's not what we allege.
Can I ask you specifically with respect to your allegations of jurisdiction against Reyes, Pineda, the people in
the individuals?
Philippines. Right. Where do you find that?
So in the complaint, we talk about the establishment of the fictitious accounts and the suspicious activity beyond those. Wong, DeGito, Torres.
Let's forget about Wong. Let's talk about the others.
DeGito and Torres are the branch managers that help set them up.
Right.
That's alleged in the complaint.
And so they're there on conspiracy claims, right?
And conversion.
Okay, all right. So, I don't know if you can, all right. Assume that we'll say conspiracy. I don't know if you can convert cash the way that you are alleging in the complaint, but let's start with conspiracy. So what are the allegations of conspiracy that you allege against them that we would find personal jurisdiction?
Against the individuals?
Yeah.
So Agarrado's...
they're Philippine. They've never been here. They have nothing to do. They work at a bank.
We don't know that yet.
Okay.
But we also don't know that...
That's what they say.
We also don't know that Wong has never been here.
Okay, but go ahead.
With respect to Agarrado, this person's name is on the account opening forms. How do I know this? We've heard a lot of discovery issues. Well, I've seen the account opening paperwork that have been produced in discovery. We are undergoing discovery. Documents have been produced. So this idea that things aren't happening till March of next year is not...
So wait, is that listed in the complaint? The allegation that Algarado's signature appears on the document?
Yes, and Capina and Capina and Pineda, for example, have these obligations to report back on the thank you letters and the due diligence and the know your client, and they didn't do it. And we argue that the inferences to be drawn on a motion to dismiss are in our favor as the non-moving plaintiff party. And all of these...
What are you alleging? How did those individuals benefit?
How do they benefit?
Yeah.
Well, people don't do things like that just for free, I don't think.
Oh,
right? And that's the-
you know what, okay,
that's the
sure, but
inference that the
what have
trial
you
court-
alleged in your complaint as to their benefit? How they benefited?
Well, for example, DeGuido and Torres, there's allegations about receiving cash.
No, that's a different thing.
So
Were they, are you talking about
withdrew
the boxes
cash.
of cash?
Yes, that's correct. And there was contradictory testimony, right? There was a hearing in the Philippines where everybody kind of told a different story. And that's what we're trying to pass. And if you look at Justice Maisley's decision on page 23 to 34, she spends 11 pages talking about the allegations, about these, see my time's run out, about the individual defendants. And we submit that the forum non, her discretion should be affirmed here, as should the personal jurisdiction. She spends 35 pages talking
So
about
back to Reyes, Pineda, Capina, Algarado. Is there something in the complaint also that establishes that they knew of the conspiracy and also that the conspiracy could not have taken place or they could not have operated without them?
We argue that it could not have taken place without all of these individuals and that it could not have occurred without each of these individuals doing what they did with respect to these accounts, these fictitious accounts from which the money was stolen out of New York and placed in these accounts.
Thank you.
Thank you, Your Honors.
I want to touch on two things my friend Mr. Loeffler said in rebuttal. The first is on hasty reversal. I think you need look no further than the analysis of the first residency prong to see a hasty reversal. Right? This is a case completely between foreign plaintiffs and foreign defendants. The first opinion says that factor counsels in favor of dismissal. The second opinion says it's neutral. That's just a reversal out of left field. The same thing happens with availability and adequacy of the Philippine Forum. First time around, the Philippines Forum is available and adequate. The second time around, it's not. It's offensive to say it's not. This is a Western ally with a functioning system of law. Mashra Bank's a case that sent a case away to Saudi Arabia. This is an available and adequate forum and a hasty reversal. The second thing is, as soon as my friend turned to the theft, what he said was, again, the theft was through the creation of the fictitious accounts. That's in the Philippines. Everything you just heard about, DeGuido, Pineda, and DeGuido, by the way, is not one of the RCBC defendants. All of that is in the Philippines. This case runs through the Philippines no matter what the theory is. On the theft side of the theory, the fictitious accounts are critical. On the laundering side of the theory, all those same individuals' conduct is critical. And all of it's in the Philippines. It's something the Philippines has an intense interest in. It's not something New York does, simply because there are correspondent accounts here. My friend says, this case is about how defendants, the hackers reached into New York, is like Die Hard 3.
I mean, isn't that exactly the point, that the money laundering with the casino chips has nothing to do with New York? The theft has everything to do with correspondent banks in New York.
It has to do with the correspondent accounts in New York the same way that...
You could not have done that theft without those correspondent banks in New York and Pennsylvania.
No, they also could have run the money through any place that could transfer.
But the question, they could have, should have, would have. They did. That's the whole point. They ran the money through New York banks. That is completely different than some casino guy cashing in chips.
So they also ran it through Pennsylvania banks.
Okay.
And in Mashra Bank, it ran through New York banks at every step along the way. And in the recent case that we cited, the supplemental authority letter on, look, that's a fraud that runs through New York. It's a fraudulent power of attorney obtained
The question
in Israel.
is it a abuse of discretion to say that when a scheme is based on, when the theft is based on money, and it could not have been stolen without it going through the correspondent banks in New York, that that part, at least, militates against forum nons?
So I'd say it's an abuse of discretion for at least 3 reasons. One is the 2 I pointed to earlier on hasty reversal, right? That residency prong and that availability and adequacy prong are fundamental reversals for nothing to do with the correspondent banks. The second one is it seems like an abuse of discretion to treat similarly situated parties the same way. What my friend is focused on is the fictitious accounts, which are not correspondent accounts. Those are accounts in the Philippines. And Wong and my clients, as pleaded, are pleaded in the very same paragraphs about their relationship to those. And the third is in Mashra Bank, the court not only found an abuse of discretion, it found an error as a matter of law by focusing on the correspondent of banks without regard or without sufficient regard to the other factors.
Thank you. Thank you all. QG versus the city. I'm sorry. Where am I at?
Your Honor.
Sorry. Oh, rebuttal. Apologies.
I'm sorry.
Thank you, Your Honor.
Then we're talked down.
Bangladesh
Yeah, exactly.
attempts to tie Mr. Wong to New York by arguing that, quote, he knew the money was coming from New York. That's not in the complaint, that's in their brief. In their brief, they allege only that Mr. Wong knew the money was coming. It does not allege that he knew the money was coming from New York. Those are paragraphs 154 and 155 of
Does
the
he have to
complaint.
know that it's coming from New York? He's part of the overall conspiracy in terms of the monies coming through the various banks?
Well, what he's accused of is laundering the money in the Philippines. Everything he did, from being allegedly part of opening up the accounts to allegedly transferring the money through the casinos, all occurred in the Philippines. The other thing that they allege in the complaint, which is critical, is that the funds came from, quote, individuals unknown to Mr. Wong. But then they allege that Mr. Wong knew the money was coming from New York in their brief, but not in their complaint. There's nothing connecting Mr. Wong to New York. This case belongs back in the Philippines.
But let me just ask you, if we find forum nons against the bank, your argument falls, you go the same way that the bank goes, either yes or no, right?
I think so. I think he
Okay.
should go the same way
That's-
as the
okay,
casinos
Well,
went.
well, the casino is another thing. I'm just saying, this bank, your 327A motion goes, falls or stands on the same
I do not
ground.
believe so, Your Honor, because Mr. Wong does not have any corresponding accounts
Okay.
in the United States.
Okay.
The complaint says that the money came from individuals unknown to him. That's
Right.
their admission in the complaint at paragraphs 435 and 447. So there's nothing tying Mr. Wong to the New York part of the alleged conspiracy.
Okay.
Thank you, Your Honors.
QG versus the city of New York.
May it please the court, Jeff Herman from Herman Law. The lower court erroneously applied the 3-prong test to this case when it should have applied this court's decision in Sean M. This court specifically held in a foster care situation that the question of a special duty and a special relationship is inherent when in a foster care relationship because the foster care agency or the government in that situation takes custody of the child. And therefore, it's inherent that there's a special duty. The lower court applied McLean. It's like apples and oranges. Apples is when there's a custodial relationship and it's inherent the special duty, like a school case, like a prison case where the prisoners are within custody, a foster care case. McLean was applying the 3-prong test, this is the oranges part, is when the special relationship is not inherent.
So McLean says two things. It says, one, if it's discretionary, then you can't sue. Two, if it's ministerial, you have to comply with the three-pronged test, correct? And anything else that implies anything else is wrong. That's what McLean says. You are sitting here telling us today that McLean didn't mean what it said when it said that.
No, what I'm saying is McLean, when it came to,
Well, what part of the three-part test do you think that you fit into?
we're not arguing for that three-part
And didn't
test.
McLean say there's only this and this? There's no ad hoc extra. In fact, that's what that plaintiff tried to do, an ad hoc extra.
No, that plaintiff did not come from a custodial relationship where they were arguing the special duty was inherent. In fact, McLean doesn't change precedent. McLean specifically cites to Pelez, which is a 2004 case preceding Sean M., which did apply the three-prong test, and Garrett, which is a 1983 case, which was a prison case. There's a whole line of cases talking about how the courts, if it's not inherent that there's a special duty owed to a particular individual, then the courts apply these other tests to see whether or not, in fact, there's a special duty that's created by the facts.
So I'm looking at McLean, 12 New York 3rd at page 204. And it says that where you're bringing a claim concerning a ministerial function, you have to plead and prove, again, that they fall under one of the well-established special duty categories.
Right. And what McLean...
That's what McLean says.
Right,
I just
right.
read from McLean. So under which one of the well-established special duty categories does your client fall?
Well, I'm not saying our client falls in one of those categories. I'm saying is what McLean was referring to is a situation where there's a non-custodial relationship. I mean, if that were true, if McLean were true, then kids in schools would have to prove the three-part test when they're abused. Victims in custody of jails and residential facilities that are government-owned would have to all of a sudden establish a new standard. They fall in the three-prong test. That's never been part, and the three-prong test has always existed. It predates this court's decision in Sean M. And so I understand what McLean is saying, but it's specifically talking about a non-custodial relationship case. In that case, in McLean, the facts were that a child was abused at a private daycare that had to register with the city. There was no argument of foster care. And so...
Right, the daycare provider in McLean was registered or regulated by the city, but the city did not have physical custody of the child.
That is correct. They did not have physical custody nor legal custody. The Court of Appeals in Pratt, a 1976 case, which is a school case, talked about when there's a custodial relationship, the duty, the special duty is inherent. And it cites the Restatement of Torts 320, which talks about custodial relationships. That's always been, McLean does not change the line of cases when there is a custodial relationship. I mean, what this court said in Sean M. is that it's very clear from the statutory scheme of foster care that the government owes a duty to the kids in foster care to protect them. And so because of that language, because that's the scheme, the special duty is inherent. We don't need, the courts do not need to look beyond and to look to determine.
I mean, that is exactly what the plaintiff argued in McLean, that it's inherent, that because it flows out of this special, that's exactly what she argued in McLean.
No, I'm sorry.
And in fact, the Court of Appeal says to the extent that Pelez and any other case can be read any other way, those cases should not be followed. That now, from now on, we have one of two ways to do this, and that's it.
Well, what the court was saying should not be followed was talking about the discretionary issue. But the facts in McLean, the plaintiff was not arguing the same things we're arguing here because it was not a custodial relationship. We're not arguing for a new category. In fact, the court in McLean said plaintiffs are actually arguing for new quasi-category They say the argument for a new category of special relationship should be recognized. We are not arguing that. The category of special relationship, we're saying, already exists. It's always existed. It's existed because of the custodial relationship, which the Court of Appeals has recognized creates the special duty. And that is because there is no question that when the law says to
So then how do you explain Mark G. versus Sobal? If you could have argued that, how come Mark G. versus Sobal didn't say, doesn't matter whether the social services law creates a private cause of action, because you got this, because it's in this situation, you have a custodial relationship, so that doesn't apply.
And the answer there is because Mark G is pairs. We have apples and oranges. Mark G is a pairs because in Mark G, the plaintiffs did not argue a negligence case. In fact, the court specifically said, we conclude that no viable common law claim has been pleaded, and we therefore grant plaintiffs leave to replead. Had they pled a negligence claim, then they would have an argument that the special duty in that
The
foster
allegation was that the plaintiffs had suffered, I think, physical abuse, right?
Yes.
In foster care. So
Yes.
it wasn't a negligence claim?
It should have been. They didn't plead that. What they pled was a violation of a statutory duty, and that was an error, I think, in the pleading, and it was a fault that prevented them from succeeding, which is why the Court of Appeals gave them opportunity to replead and even suggested if you plead common law negligence, well, then there's going to be potentially a different result.
Oh, okay. I'm not sure that that's what they said, but you,
Well,
you have time on rebuttal.
Thank you.
So, counsel, how do you respond? Because it seems as if I've read McLean incorrectly. Apparently, it doesn't say what I thought it said.
No, Your Honor, you're absolutely reading McLean correctly. This is Philip Young on behalf of the city. The Court of Appeals in McLean, and then just last year in Ferriera, Maldovan, Howell said that there are only 3 ways that you can establish a special duty, 3 narrow categories. There are no exceptions, as Your Honor noted. In McLean, the plaintiff specifically tried to ask for an ad hoc exception to the special duty rule, and the Court of Appeals shut them down and said that we don't make ad hoc exceptions to the special duty rules, even for an especially appealing class of cases. So here, plaintiffs does not try to fit this claim into any of those 3 special duty categories. They try to create a unique standalone category, and that's exactly what they're asking for, an exception to the special duty rule. And they base that exception on this court's 2005 decision from 18 years ago in Sean M. And it's quite clear, as the Fourth Department has held and as the Court of Claims has held on 2 different occasions, that Sean M. is functionally overruled by the Court of Appeals decision in Mark G. in 1999, and then following up on that, the Court of Appeals decision in McLean, which applied Mark G. and held that because there was no private cause of action that could be implied from the provisions of the social services laws that apply to foster care, that the plaintiff could not allege a special duty under those provisions, under related foster care provisions.
But does the Fourth Department case in any way vary from McLean?
No, Your Honor. The Fourth Department case, Weiss-Broad-Moore, from just this year is entirely consistent with McLean. It applies McLean, it applies Mark G. It cites both of those cases. It says that those decisions together essentially overrule Sean M. and also some inconsistent precedent in the Second Department as well, Bartels and Barnes.
And in the Fourth Department case, Weiss-Broad-Moore, the facts, I thought, of the issues were similar to the issues here, or almost identical to the issues here.
Yes, Your Honor. The facts are almost identical. I believe it's the same counsel for plaintiffs. It's a CVA case alleging abuse in foster care home by third parties.
So your adversary mentioned that if we read McLean the way I read McLean, then there's an issue in terms of school settings.
No, there's no issue in terms of school settings. I think the Court of Appeals has been clear that schools and prisons, the physical custody context, is sort of a complete set-aside, a sui generis category, where a duty arises as a result of the physical custody that the school has or that the prison has over the student or the inmate, Once that physical custody ends, as the Court of Appeals held in Pratt, the moment that student steps off the bus, the duty falls away. And here, there's no allegations of physical custody at all. This was abuse that occurred in a private foster care home. If there are no further questions, the city rests on its briefs.
So I'd like to go back first to McLean, because I want to just read exactly what the wording is, because I don't think it says that the only way to find a special duty is a three-pronged test.
So let me just say, the Fourth Department, that's what the Fourth Department has said,
Yes,
right?
and I think
So
the
you're
Fourth
saying to
Department's-
us, the Fourth Department is wrong, all the cases before this are wrong. The Court of Claims case that said that McLean is basically overruled, Sean M., all of them are wrong.
Exactly. They are, to me, clearly wrong. And I think when you read the cases clearly and you read their decisions, they don't make sense. And let me go through McLean again. So McLean doesn't say the only way you could ever find a special duty is a three-pronged test. It says, as we have said in Pelez, a special relationship can be formed in three ways. And again, these are the facts where there's no custodial relationship. And to say Mark G stands for the proposition that there's no special relationship in a foster case it's just incorrect. Because they specifically say in Mark G, this is a claim for a statutory breach, not a negligence claim. It says, although we do not as a matter of law rule out the possibility of any such common law claims, we conclude that no viable common law claims has been pleaded. Had they been pled, we'd have a different situation. They weren't. And to say that this doesn't impact school cases, I believe is an error. Because again, Pratt, that was cited by defense counsel, was decided in the 1980s. I think it's 1986. And so if the factor there was custody, how can we say the municipality does not have custody of a foster child, but they do in a school case? They physically take kids out of their homes. The parents lose all rights to their children. The government is now responsible for the care of these children. They are physically in the care of the government, who may place them in homes, but even the courts have always said that the foster parents are temporary caretakers. The legal responsibility, the non-delegable duty, remains with the city of New York in this case. The legal custody is certainly with the city of New York. There's no parents to make decisions for these children. To say that a temporary placement in a school is somehow, a higher level of duty for a child than foster care is just flat out wrong. It's not realistic to think a child doesn't need to be protected in foster care. It is the most important, one of the most important things the government does is taking custody of a child. And to say that, no, there's no special duty to this child is just wrong, and it falls, I think it flies in the face of precedent. And McLean never, to overrule this important decision in Sean M. the Atlantic cases, McLean would have said that. The Court of Appeals would have said, we are overruling the long line of cases that in foster care cases, you have to meet this three-pronged test. They didn't say it in McLean about foster care, they didn't say it about schools, and they didn't say it about the prisons.
Thank you.
Thank you.
People v. Corey Jimenez.
Good afternoon, Naila Siddiqui on behalf of Appellant Corey Jimenez. The search warrant affidavit lacked probable cause to search the Mazda sedan listed in the search warrant. The factual allegations in the affidavit that Mr. Jimenez allegedly insistently asked that the keys the police officer held in his hand while he was handcuffed be given to his wife, who was present during the arrest, and the mere possession of the keys and knowing the license plate of the car were provided no link to criminality and were capable of innocent interpretation and do not.
Counsel, is it your position that a search warrant cannot be issued where there's a gun involved and the gun's not recovered, that a search warrant cannot be issued for a home or a car? Or are you specifically arguing that because this particular judge referenced the innocuous or maybe not so innocuous statement of "take my keys," that's what made the search warrant improper? Because those are two different things. Because if you take away the statement, why wasn't the search warrant appropriate?
If you take away the statement, then all they have is that he was holding keys when he was stopped by officers, and he had nothing on his person. It was 24 hours after he was in a bodega with a gun. There was no link to criminality. Now, the prosecution could have gotten a search warrant for the home and the car as long as they articulated specific facts to search the home and specific facts to search the car.
So you're saying it wasn't enough that the day before he was in the bodega with the gun threatening someone? That wasn't enough to get a search warrant?
That was enough to arrest him when they saw him, but that was not enough to get a search warrant as it pertains to the car without more. If, for example, the bodega owner or the person in the bodega saw him leave the bodega and get into a car and describe the car, then there might be a link to criminality where he is now taking the gun that was on his person and going into a car. Without that link, there's no link to criminality.
So you're saying that when someone is observed with a firearm, if they don't have that firearm on them when they are arrested, no search warrant can issue otherwise?
No, that's not what I'm saying. It has nothing to do that there was a firearm and they can't issue a warrant. They can absolutely issue a warrant if they investigate the case and establish facts, and that is consistent with.
So how about the fact that he has car keys in his hand? So he clearly has a car and he has a home, and he doesn't have the gun on him. So isn't that enough to search the car and the gun?
Not under Court of Appeals precedent in Gordon, where a gun was suppressed on similar facts, where they could not search a car that was on the premises, and the Court of Appeals relied on a case in Hansen where there was a search warrant for both a car and a home, and the Court of Appeals separated the two and said the search of the home was okay, which we're saying the search of the home was okay, and precedent is consistent with that, but the search of a car, because it lacked actual facts. If he was near the car at the time of the arrest.
Why would the search of the home be fine, but the search of the car not be fine?
That the precedent separates the search of homes separate from cars. Gordon and
we know that he owned the vehicle, or at least he had control over the vehicle because he had the keys to the vehicle. And we also know that vehicles, by definition, are transitory, right? So someone could have driven the vehicle to Connecticut or something of that nature.
Yeah, well, so first, with respect to the ownership issue, there was an affidavit in this case where his wife said that she had actually asked for the keys and that it was her car. So in terms of ownership, he may have just simply been holding the keys in that case if it was just going to be for ownership, right? But in this case, courts have held for searching homes, specific to homes only, that is reasonable to assume that people keep things in their homes, that's where they sleep at night.
But he's got the keys in his hand at the time, so we know he has a car, and you're saying that it's not reasonable to think that maybe he had the gun. And the police officer says, I've done 100 million of these. People keep the guns in their homes and their cars.
Well, I'm saying that the Court of Appeals has held that is not enough.
Well, in Gordon, actually, it was the search warrant, I think, was only for the home, and then they also searched the vehicle.
Yes. So
that's why it was found to be improper, was because the search warrant only covered the home. It did not cover the vehicle.
Well, in Gordon, the court specifically said that not only was the car not particularly listed, there was no particularized probable cause as to the car, and they reaffirmed Hansen, where it's the same set of facts, except that both the car and the home were listed, and there were no particularized facts as to the car, where they just saw people going back and forth between the car and the home, that would allow for the search of the car. So here, it's the same. Merely having keys in the hand is the same.
So he has the
as-
keys, and also I think the officer attested to the fact that he had been involved in I don't know how many arrests, and that individuals sometimes or commonly secrete weapons in their vehicles.
Well, so he did testify that there was that he did 110 robberies. There's no allegation of robbery. We have no idea how many search warrants he's executed when he stopped someone on the street to search for a gun. And so while training and experience is something that can be considered and as part of a factor, it cannot substitute probable cause. And so the court not only so there was no probable cause as to the search warrant, and if you do believe that there was probable cause, the court erred in summarily denying a Franks hearing because the defense attorney made a showing of a false allegation that was used for probable cause, which the people in their first point argue that the insistent fashion was.
Based upon the wife's affidavit that it was her vehicle.
Yeah, so at the very least, a hearing should have been ordered, both as to the statement that it was his car, as well as the Franks issue on the insistent fashion of giving the keys.
Thank you.
Good afternoon. May it please the court. Jillian Lewis on behalf of the people. Your Honors, once a warrant has been granted, it just needs to have been reasonably concluded that probable cause existed. And that's exactly what existed here. Probable cause existed to search the home and the car of defendant.
And that was based upon the fact that 24 hours before the defendant was seen in possession of a weapon?
That was based on the surveillance video that he was in possession of a weapon, in addition to defendant subsequently identifying himself in that video. That defendant was found with the car keys on his person and later said, "Those car keys are mine," described the make and the model of the vehicle and said they were the sole keys, and described the license plate. And in addition to that,
so then where do we place that statement that the police officer, attested to, that the defendant said in such an insistent fashion, take the keys, kind of implying, well, hey, guess what? Take the keys. We don't need them searching that.
yes, that added to probable cause of the totality of the circumstances, but it was one of the factors that added to the probable cause, the insistence that Officer Scott observed him giving the keys to his wife.
What about the wife's affidavit stating that he did not insist that she take the keys and also that the vehicle belonged to her?
Yes, that statement from his wife was self-serving and went to the fact that she was trying to protect her husband. It really just, even discounting that statement, there was enough probable cause and there was no need to issue.
Based on what? Without that statement, what else are you saying created probable cause? The video?
The fact that he was found with the weapon, the fact that once he was
found with the weapon,
or he was seen on
Right, the
surveillance video
video.
with the weapon,
Right.
he was identified 24 hours later on the street, had the keys on
And
him,
he said, "That's my car."
and later said, "That's my car," described the make and the model of the car, and the car was then eventually located next to his residence. The fact that he said it was his sole set of keys gave that ownership that provided probable cause to search his home and his car. Those are the areas that he had control over. And I want to turn the court's attention to the cases cited, Gordon and Hansen. As Your Honor noted, in Gordon, the car was not listed on the search warrant. It was the entire premises was the target of the search warrant, and a car happened to be on the premises. Here, we knew the make and the model, and we knew who the owner was because he told officers, "This is my car." So that also leads to Hansen, where the Court of Appeals found there was a car described as going in and out, but there were multiple people associated with the car. It wasn't clear who had ownership of the car. Here, defendant's own statements contradict that of Tiffany Jimenez, that it was his car, where in her affidavit she said, those were my set of keys. And going back to the issue of, a Frank's hearing in order to determine the veracity of the statements that Scott made, Scott was also relying on additional witnesses and officers in order to make out his statements. So a Frank's hearing would not be necessary.
And the wife's affidavit would not have been sufficient in order to order a Frank's hearing?
No, Your Honor, because it contradicted just the ownership, the way in which the keys were assessed, but ultimately, defendant himself said, those keys are mine. They're the keys to my Mazda, the car is mine. So that isn't an issue that required a Frank's hearing.
Thank you.
Thank you.
Very briefly as to the video provided probable cause to arrest him. It did not provide probable cause to get a search warrant for a car. Otherwise, anytime someone is seen carrying a gun, they would automatically waive their Fourth Amendment rights. In terms of whether or not the wife's statement is self-serving, that was not concluded by the court. That is what should be determined at a hearing, and that's why a hearing should have been ordered. With respect to the statements, that's my car. Now, the Frank's hearing is specific to the insistent fashion, and while it is true that the affidavit did say that I am informed by Officer Francita, a Huntley hearing was held as to notice statements. At that Huntley hearing, Officer Francita did not testify. The sole officer that testified was Officer Scott, who stated that he was present during the entire interrogation, the entire questioning, and so he was actually a witness too. Officer Francita did not tell him, but he was a witness too, and that was only found out after the hearing. So, and when he testified, he only testified to Mr. Jimenez identifying himself. He never testified that these statements, that this is my car and this is my license plate, were ever even said. They never took notes. And so that, at that point, when the hearing was held as to the other statements that they were seeking to suppress, the attorney reissued her request for a Frank's hearing because now the other issue of ownership is called into question under arguably both Frank's, and it hasn't yet even, they're determining probable cause on statements allegedly made after Miranda, but we've never really had a hearing. And so courts have held that you can, a search warrant cannot stand if probable cause is based on an unlawful statement. So if those statements of that's my car, this is my license plate, I drive it every day, which was not what he said, but if those statements were unlawfully obtained, the search warrant could not stand.
Was that brought to the attention of the hearing court?
Yes, it was. It was brought, and then she denied a request. The attorney asked the request, raised the issue of the Franks, because the officer Scott...
the Huntley.
Oh yeah, the Huntley hearing. Because Officer Scott didn't testify to those statements, she basically questioned in front of the hearing court, it leads me to whether or not they were even uttered. Because, and he did testify at the hearing, that they had the keys, they drove around looking for the car. So whether or not he actually knew the license plate, if the officer who was present the entire time during the Miranda statements did not even testify at a hearing when he's asked what happened, that omission leads one to believe that those words were never even uttered.
And so when was it that the defendant the defense attorney realized that these statements had been made?
So what happened, so they were noticed statements, and in the affidavit is when they realized, so in the search warrant affidavit, it suggests that Officer Francita was the one who did questioning and read Ms. Miranda, and that's when the statement was made. She made the request in her original motion to controvert and seeking a Frank's hearing. She sought a Frank's hearing, and she called it a Huntley hearing because it was for unnoticed statements. So so she just wants to have an opportunity to have a hearing on statements in the affidavit, and she does that in her first motion, for statements in the affidavit, the probable cause, which has not been tested yet. So if the court said, okay, we're gonna allow you to test all of the statements that were allegedly said at the hearing, it would be determined whether or not probable cause was sufficient as to those statements. Those statements, it was never tested. In fact, a county hearing was held as to the statements at the same time frame, but the officer never testified that those statements were even said.
But once the application was denied as to the statements made in the affidavit, meaning the application for a Franks hearing was denied, did counsel then ask for a Huntley to determine the voluntariness of the statements made?
Yes. So first, she asked for a Franks hearing because at the time, all she had was an affidavit.
I understand that. So afterwards,
She asked for both at the same time because the affidavit reads, I'm informed by.
After she's made aware of the fact that the Franks hearing is denied, does she then, bless you, does she then at that point ask for a Huntley to determine the voluntariness of the statements?
Yes.
And the court says no?
Well, the court found, in the court's decision, the court does say no, it finds it without merit.
Okay, thank you. Thank you both. I guess I'm going to call Hutchins v. Madison Square Garden then?
Yes, Your
Okay.
Thank you, Your Honor. Randy Mastro of King and Spalding for Appellant Madison Square Garden, and I will be uncharacteristically brief because I do not have an adversary. And my adversary
Never stopped you before.
Well, Your Honor, I have something to say. Yeah, my adversary isn't here for a good reason. Doesn't object to the relief sought here.
Exactly. Said never mind.
So did even more than that. Said, in fact, quote, to this court, we recognize and are no longer disputing that MSG's actions relating to this specific temporary exclusion policy did not violate CRL Section 40-B. Your Honor, I think that says all that needs to be said here, but I'm happy to answer any questions the court might have. Otherwise, I will rest on our papers, which I think have explained all of the issues and the more than half a dozen reasons why, as Your Honor, Justice Weber found in the Ambach case, that when it comes to statutes in derogation of the common law, they have to be strictly construed and cannot be altered by implication. Here, revocation isn't even mentioned in the statute, let alone restricted in the way that Justice Frank did in his orders here. So the claim should be dismissed, and the summary judgment he entered pre-answer, pre-discovery, exceeding the statutory fines should be reversed. Thank you, Your Honor.
Thank you. Have a good day.
Thanks.
Appellate versus McGilvery. Messed that up.
May it please the court, Michelle Russo on behalf of the plaintiffs' appellants, Frank and Elizabeth Pitelli. The grant of summary judgment in this medical malpractice case was extremely inappropriate. To begin, defendants, both of them, failed to demonstrate entitlement to summary judgment by overlooking critical evidence in terms of ruling in or out the injury at hand, which was a ruptured triceps tendon. The classic signs and symptoms of that injury were present in this case. They were present at the time that the plaintiff appeared at the emergency room, and they were present on July 12th, and they were present at the time that he was examined by Dr. McGilvery on, I believe it was August 6th. What were those factors? Number one, the hard fall on an outstretched arm was a classic, well-known mechanism of this type of injury. That was ignored by the defendants and their experts. Also ignored was the fact that the plaintiff testified that when he fell, he heard a pop, which
But
was
that particular part of it wasn't in any, was that in any medical record that he heard a pop?
the fact that the plaintiff did not say that was not included in the medical record. He testified, however, Your Honor, that he heard that, and that there's testimony from his wife, and that's on page 1248 of the record, that she was present in the emergency room when she heard her husband tell Dr. Chale that he heard a pop when he fell.
So,
Also,
again, he doesn't testify that he told anyone that, and there is nothing in any of the medical records reflecting that any of the doctors heard that. Is that correct?
that would be correct, Your Honor. However, this brings me to my next point, which is the fact that there's a lot that's not in the medical records that should have been in the medical records. So we cannot
But I
count.
mean, so we have what we have, right? He says, he doesn't say he told anyone, and none of the doctors say that they heard that from him, and none of the medical records show that that was said to those doctors. So assuming that, let's put that aside, what next?
Okay. Next, Your Honor, is the conflicting evidence in the medical records with respect to the range of motion. We have the fourth-year medical student who documented when he first examined the plaintiff that there was restricted range of motion as well as swelling and pain and tenderness. Whereas we have Dr. Chale's note, which is frankly illegible, but assuming that his testimony is accurate, that in fact what he scribbled on page 1784 of the record was stated that there was full range of motion with pain. That conflicts with the testimony. They fail to consider that. They failed to consider the objective evidence that was presented by the x-rays of the swelling in the exact location of where the injury ultimately occurred, behind the elbow. The fact that that existed meant that you could not rule out in this instance that there was a tricep tendon rupture, and that it was necessary to then, in the differential diagnosis, to proceed with an MRI. They also failed to acknowledge plaintiff's testimony, which was evident in the records, that he had large swelling in the area of
So
where...
that goes to, I guess, to some extent, your claims as to Dr. McElvey, that based upon the swelling, he should have performed a different test or a different examination?
Well, Your Honor, it's both with respect to Dr. Chale and with Dr. McGillivray, but yes, Dr. McGillivray having...
So what should Dr. Chale have done based upon the swelling?
Based upon the swelling and the fact that this was evident in the x-ray, so the x-ray, although it said that there was no fracture, it was not definitive in terms of ruling out the injury at hand, and that's where the MRI, which the defendant doctors acknowledge, is the standard, is the gold standard in
So this is when the
determining this injury.
defendant, excuse me, this is when the plaintiff first comes into the emergency room, right?
I'm sorry.
That Dr. Chale
Yes.
sees him?
Dr. Chale examined him, but after the medical student examined him. There's
Well,
also,
Dr. Chale said that he was present while the medical student examined him, right?
I believe, Your Honor, that he said that he spoke with the medical student. I'm not 100% sure that he was present at the exact same time. But regardless, the notations are in conflict, which, again, means that they did not demonstrate their entitlement to summary judgment.
You have time on
Additionally-
rebuttal.
Oh, thank you, Your Honor.
May it please the court, I'm Balinder Rikhi. I represent Dr. McGillivray and Hospital for Special Surgery.
Counsel, I have a question in reference to the swelling that is alleged to have been present and the fact that just manipulation wouldn't have seen the tendon tear, and that's why you order an MRI, because this is what plaintiff's expert attests to, that an x-ray wouldn't rule that out because x-rays rule out fractures, but the swelling is indicative of something more, which is why an MRI should have been ordered. How does defendant's expert address that sufficiently?
Yes, the defendant's experts do, and they say that in this particular case, based on the findings on physical examination, an MRI was not required. Plaintiff's position is essentially an MRI is required in all situations. It sounds like that, the way that they present their argument. And the position that our experts have taken and that Dr. McGillivray has taken is no. You examine the patient, you take the patient's history, and based on those findings, and if there is a clinical indication of a rupture, then that would justify sending the person for an MRI.
But that's the point. The point is that the argument is that based upon the swelling, you really could not do a purely clinical examination, that you needed more. You needed the MRI.
Right, but the swelling can occur in all kinds of instances. In this case, there was an olecranon, sort of swelling, and it was at the tip of the elbow. The position that the plaintiff's experts take is they say that you can't rule out a rupture without an MRI, but they're unable to say that first of all, an MRI could have shown either one of those two things. It could have shown that Dr. McGillivray was correct on his clinical examination, or it could have shown something. It could have shown a tear. In fact, he was asked at his deposition, could there have been a tear when you examined him? And he said, yes, there could have been a tear.
So would you...
But not a rupture.
Would you normally, if someone came in with swelling, would you normally order an MRI? If I came in with an ankle strain or sprain, would someone order an MRI?
Not with more findings. And in this particular...
And a negative X-ray. I come in with a swollen ankle and a negative X-ray. Would you immediately order an MRI?
You would not. You would not. There would have to be an indication to order an MRI. And in this particular case, in addition to, there would be other findings.
Well, what about the fact that later on plaintiff claims that he heard a pop when he actually fell?
Well, he may have heard a pop, but he didn't tell anybody about it.
And also limited range of motion, I think he stated at some point in time.
He had range of motion on examination, but of course he had fallen and he had hurt himself, so there was swelling. And so obviously there was some limitation in motion, but there was no bulging. There was no muscle that showed that it had retracted. The issue over here is he's saying that there was a complete rupture of my triceps tendon rupture when I saw Dr. McGillivray on August the 6th. That's what he's saying. And because you didn't make that diagnosis and because you didn't send me for an MRI, the MRI would have shown a retraction and I would have been able to have an operation much earlier and I would have had a better recovery. And the problem here is that we don't know when the retraction took place. We had 3 physicians who examined him, including Dr. McGillivray, and no one found on examination a triceps tendon tear or a reason to send him for an MRI. The other problem is that the plaintiff's experts, they themselves, they all say that the rupture took place on the 16th of July, but there's no way for them to establish that because there's no evidence, there's no definitive evidence. The only evidence we have is the physical findings on palpation and examination by 3 physicians, one after the other. So what the plaintiff's experts then do is, because they have to establish a rupture during the treatment by Dr. McGillivray. So they say, let's extrapolate. Let's take a look at the date that the retraction was discovered, which was September the 11th, when he was examined by Dr. Elizaroff, and we'll work it backwards. And they come up with various, Dr. Zilberfarb, one of their experts, the orthoped, he said, it occurred many weeks before September the 11th. Well, what's many weeks? 5 weeks it was between when McGillivray saw him and September 11. Well, that's many weeks. Then he says that at another point he says there was a 2-month delay. Dr. Painter, who's the emergency room physician, he says it was delayed by many weeks. They have to be able to show that this rupture occurred when Dr. McGillivray examined him. It could have occurred on the day after he examined him. It could have occurred a week after he examined him, and it still would have fallen in that several weeks. It's a kind of an approximation that simply isn't sufficient from an evidentiary point of view to say that it existed at the time that Dr. McGillivray examined the patient.
Thank you.
Good afternoon. May it please the court. My name is Ingrid Rodriguez, and I represent Dr. Chael and the other entities. Just for the sake of brevity, I want to point out one of the first things that appellant stated. One of the first things she stated is that there was swelling on the X-ray. Her expert, Dr. Paitner, states that he reviewed the X-ray that were taken on July 16, 2012, and this is on page 24 of my brief, in which he affirms that there was swelling above the olecranon behind the elbow area identified by the fourth-year student and by the plaintiff. We have a radiologist that reviewed this. Dr. Eric Feldman reviewed it on July 16th. He's a board-certified radiologist, and he says there is no evidence of joint effusion. This was at the arm. This is the joint. There's no evidence. So how is her expert all of a sudden coming along and saying, oh, he's wrong too? You know, there is nothing to show that there was a tricep tendon rupture on July.
The conflict between experts, is that not a reason for denial of summary judgment or a question for the jury? Let them decide.
Your Honor, the experts always disagree. But the whole thing is that our experts are based on facts. The plaintiff's experts are basing on speculation and in this particular case, making stuff up. You know, here she says that I reviewed them. And you have a board-certified radiologist that says there's no joint effusion. He's also speculating. There's no MRI, there's no CT, there's no CT scan that showed that on July 16th, 2012, he had a tricep tendon rupture. We have the facts that were in the medical records.
That's because no one ordered any of those things.
Well, Your Honor, but there was no clinical suspicion. Actually, you know, it's funny because I was looking at, there was a court officer here that was here before, and he looks like he was a weightlifter. And I'm looking at his arms. Look how big his arms are. You know, our doctor examined his arms and saw him and said he examined it and found that it was intact. Also, Dr. Mantia, he saw Dr. Mantia 8 days later. Dr. Mantia examined him as well. Nothing. You need clinical suspicion to order an MRI. Dr. Mantia, who examined him, found that there was a tricep contusion. He didn't sign. And one of the other things that none of the records say is that the extension, there's not one place in the records until you see on September, I believe 11th of 2012, where he sees Dr. Izarad, and she says, I have a hard time extending. I can't extend. Nowhere else is there. And the fourth-year medical student said he had difficulty on flexion, not extension. Never does he say he can't extend. So, Your Honor, the issue is he's saying that a tricep tendon existed on July 16th, 2012. That's what they're alleging. A rupture existed, not an injury, not something else. Maybe an injury could have existed at that point in time, but the allegation against my client is that it was ruptured, and there's nothing in the medical records to support that a rupture existed at that time. Any question? Thank you, Your Honors.
Thank you.
There was clinical evidence on July 16th and all of the signs and symptoms of this type of an injury, which Dr. Chael testified were signs and symptoms. The swelling, the plaintiff's testimony that he could not extend his arm, the tenderness behind the elbow, the fact that there is no evidence other than
it said able to move arm with pain, no pain on rotation. X-rays revealed joint effusion to the elbow, but no evidence of fracture, dislocation, or other acute injuries.
The plaintiff's testimony, Your Honor, was very clear that right after the accident, he could not, he was holding his arm like this, he could not straighten it out. It's all over the record that there was swelling. The X-rays
No,
showed
but nothing in the record that he couldn't go like this.
there was evidence that the range of motion is vague in terms of what was in that emergency room record.
Well, that's what the emergency room record says. I mean, it says able to move arm with pain, no pain on rotation, joint effusion to the elbow, no evidence of fracture, dislocation, or other acute injuries.
But combined, Your Honor, with the mechanism of the injury, which is well recognized.
Again, and
this-
where were any of the doctors told of the mechanism of the
The
injury?
plaintiff came in, Your Honor, and explained and said exactly what happened.
He didn't testify that.
Oh, he did, Your Honor.
He didn't
On
say,
the contrary,
I fell like this.
Oh, absolutely, Your Honor. He testified that he came in, that he was struck by this tree. He was flipped up in the air.
When you're talking about the mechanism of the injury, you're saying because he was at 180 degrees. That was nowhere in the medical record.
Medical record said he was knocked over at work and landed on his elbow.
But Your Honor,
I'm just saying what the medical record said.
I understand that, but I'm saying what the plaintiff testified to, which is evidence, which is in.
Yes, but the medical records, which were taken at the time when he came in to see the doctors, is something different than what he testifies to later.
Right, because this is what the medical records, as to what he told the physicians, it goes to their treatment of him, because this is what they are told, how he fell. And that's the basis, in part, of how they treated him.
Of course, Your Honor, but can we assume that everything that he told them was in that medical record?
Did he testify that he told them, did he testify in his deposition that he told them that he was in 180 degrees, that he felt like
On an
this?
outstretched arm. Yes, Your Honor, it's definitely.
That
I
this is
didn't
what he
see
told
it.
them, that
I
he-
didn't see it. I think he said that's what happened, but I don't think he said to any single doctor, certainly not at the ER, that that's how it happened. And I didn't see that he told any doctor that.
That is in the record, Your Honor, if you just.
Tell me where
I
he
will.
testified, I came in and told them that I fell on a 180-degree angle. Because it's not just that he fell on his elbow. That's not what your doctor's saying. Your doctor's saying because he fell like whatever, 180, I guess is this.
Right.
Right?
But Your Honor, let me just point out a couple of other factors that needed to be considered to show that this accident, that this injury occurred on on July 16th. That is the objective evidence of atrophy that was exhibited on September 11th when he went in for that exam. That atrophy does not occur initially, as counsel indicated, that there was no indication that there was a muscle retraction on July 16th. I would agree with that. The muscle doesn't retract instantly. It's not a rubber band. The atrophy develops over time, which is what happened here. There's no other traumatic event that occurred. There's no evidence other than their speculation about weightlifting that.
Well, his regular doctor didn't find it, right?
His regular doctor, well, number one, Your Honor, that evidence with respect to the Dr. Manchia's records, that should never have been considered by the court because it was uncertified. It was inadmissible.
Well, I mean, okay, we're done with it, but we're here with a record in which that's where.
But it should not have been considered, Your Honor. It was inadmissible. The doctor was no longer alive. There's nobody to vouch for whether those records were accurate, what he asked, what he didn't ask. So that should not have been considered. But even
assuming that that was considered, his own doctor didn't find that weeks later.
His own doctor, who was not an orthopedist and did not, we can argue, did not know precisely what to look for with this type of an injury.
Can I ask if the emergency room doctor referred him both to his primary care and his orthopedist following that visit, how is that a departure? How did he depart?
Again, Your Honor, there's a dispute as to whether or not he did refer him to an orthopedist. There's nothing in the records, if we want to rely solely on the records. Okay, there's nothing in the records that he referred them to an orthopedist.
No, told him to go to an recommended.
Told him to go to an orthopedist. I think
it says follow up with your doctor, though.
Right, it didn't say specifically an orthopedist.
Okay, thank you all.
Thank you, Your Honor.
Durst Pyramid versus Silver Cinemas.
Good afternoon, Your Honors. I'm Attorney Donald Harwood. I'm appearing on behalf of the defendants, appellants, Silver Cinemas Acquisition Co. and Silver Hold Co. The defendant was the owner and prior operator of a movie theater, Landmark Cinema, at 57th Street, which is no longer in business. There are 3 issues raised, all COVID-related, in this appeal. One concerns the notice of termination, which is the predicate for the breach of contract action, which was served during the state's moratorium.
On evictions.
On
There was a
evictions.
moratorium on evictions.
Yes.
Your client was not evicted.
Well, the moratorium forbids.
Specifically states evictions, but your client was not evicted.
Well, they served a notice threatening eviction, both a cure.
Prior to serving that notice, your client surrendered because the good guy guarantee didn't want to keep going. So your client surrendered the premises and wrote a letter through their lawyer that says, we are surrendering the premises as of today. So there could not have been an eviction because your client, to cut off their own liability, and probably rightfully so, because that ends the good guy guarantee, or may end the good guy guarantee, and certainly starts the obligation to mitigate, right? There's no possibility that your client's going to get evicted. So how could 20228, which says you shall not start or continue an eviction, how could that be even relevant?
Well, they took the position that we were still in possession when they served the default notice and when they served the termination notice. And in fact—
When they brought this lawsuit, did they seek to evict you?
No.
They're only seeking
They
money
don't—
damages.
No, but it doesn't change the fact that the notice, no termination notice, and I usually represent landlords, we never issued a termination notice threatening a termination of the lease. From the date of May 2020 through January of 2022.
Did you have anybody who surrendered the premises to you?
Of course.
And
numerous people had surrendered their premises.
So all I am saying to you is, okay, but it doesn't matter because the statute only prevents landlords from evicting, and that could not have happened to you because you surrendered.
Well, they claimed not, and we went back into the premises after the default notice.
To clean up all your stuff. You didn't go back
remove
in.
other
Right.
objects.
You did not
And
re-enter
the important point is the termination. Why did they do this instead of waiting? Because they wanted to trigger an accelerated rent damage claim because they couldn't otherwise do that. So the proper course would have been, as our firm did at the time, to wait until that moratorium lifted before you serve a termination notice. You can go into court and sue for damages, but you can't initiate an eviction proceeding with a threat of termination. The other point in the brief—
But doesn't that hurt you? Right? The guarantee is going on. If you want to wait a year, the guarantee, I assume that you wouldn't want that because the guarantee then continues for more than a year. Correct?
Right. But so you
you're
can,
arguing
you
that
can,
you're- that
you can
you think your
surrender the
client
premises in response to a threatening notice, but if
But you surrendered before. You sent the notice saying you were surrendering.
they claimed not. They claimed we were still in possession, both in the default and termination.
It doesn't really matter, but what is what's the next point?
Okay. The other point is this is the last in a long line of COVID cases. Frankly, none of them have been successful in the first department. The thing that makes this case different is this is a movie theater.
No, the thing that makes this case different is that there's actually a force majeure clause in the lease, which, you know, in the prior cases, we said, oh, well, if there had been a force majeure clause, you know, maybe there should be one. There's actually one in this lease.
Yes, but the force majeure clause in this lease applies to construction delays. It does not, and if you look at it in paragraph 15, it's about landlord's work, and landlord is not going to be held liable or responsible if there are delays in the work caused by force majeure. There's another clause.
Emergency.
Right.
Is that language not in there?
It's in paragraph 15. And likewise, delay might be a delay in tenant's initial work. So our position is that the force majeure clause applies to construction delays. There's no hell or high water clause in this lease. There is a force majeure clause in connection with construction.
Government regulations and restrictions.
Right.
Governmental preemption in connection with a national emergency. How is that construction
Because
related?
it's in section 15 of the lease. So
What kind of construction issue is related to a national emergency? I'm just wondering.
could be you're doing construction, you hit a gas pipe, you have,
That's a
National emergency?
well, I'm just saying,
Think about that on rebuttal. Maybe you can come up
I'm
with
just saying that there's a fact
You can think
issue.
about it on rebuttal. Maybe you can come up with something. Thank you.
Thank you, Your Honors. My name is Ethan Cohen from Rosenberg and Estes, representing the respondent.
So do you take issue with the statement that they surrendered? Is it your position that they did not surrender?
No, Your Honor, they clearly served a letter saying we surrendered. The only issue was whether they surrendered in the condition required by the lease, which was determining whether the guarantee would continue or not, because there was issues with whether they took property out or
That
left
goes to the
left in the
defamation
condition.
claim, right?
Yes, Your Honor.
They claim that you defamed them because you made statements apparently that they took all the fixtures and the seating from the
Quote,
theater.
yes, that they were still showing the space except for the stuff that they
And I guess you need seats in a theater.
Yes, Your
Movie
Honor.
theaters.
Exactly, Your Honor. So, and with respect to the force majeure clause, this case is not about the nature of the business, as this court has repeatedly held. It's about the language of the lease. These are sophisticated parties. They contracted.
So let me ask you, why did you serve a notice of default after they surrendered?
The notice of default was advising them that they owed rent and that they had an opportunity to cure that default. And when they didn't cure, they terminated the lease. At that point, they had already surrendered. This case was brought to collect on the unpaid rent. The breach of lease provision has nothing to do with this claim that there was an eviction notice. It is a fact that there was a lease that they breached, that they didn't pay the rent, and that.
So what you're saying was basically just to make it all clean?
Sorry, Your Honor?
Make it clean, the termination to be clean?
There was, at the time, they served a notice of default just advising them of the breach.
Did you ever seek eviction?
No, Your Honor. There was no eviction cause of action in this case or any other case. They had already surrendered possession, as you pointed out, to cut off their own liability.
Well, they surrendered possession, but apparently they were still in possession.
They were not still, there was a claim that they had not surrendered in the condition required by the lease, so the landlord claimed that they had not cut off their liability under the guarantee for that reason.
Oh, I see what you're saying, because they didn't leave it broom clean?
And because they took out
Yeah.
seats and fixtures from the.
They did leave it broom clean because they did. So it was broom.
Okay.
Super cool.
Thank you.
Thank you, Your Honors.
Was broom clean.
I do want to hit on the defamation claim. The lower court denied the motion for summary judgment on the fixtures. The only thing that the tenant took out of the space were removable chairs and basically what's referred to in the industry as FFE, furniture, fixtures, and equipment. They don't allege that there was a theft or a conversion of property in the complaint. They don't allege anything like that. Yet in the IndieWire article, representatives of the landlord said that Landmark had basically stolen their property. We contend that that makes out a valid defamation claim because it's slander per se to accuse somebody of a crime, nor should it be privileged because...
Well, wasn't that what they said in their complaint? Isn't that exactly what they charged you with in their complaint, that you took
No.
the stuff out and you shouldn't have?
They never say in the complaint anything like this property was stolen. They say that property was removed, but when...
In derogation of law, right? That you didn't have the right to the property and you took it. Isn't that what they sued you for?
If you enhance or exaggerate something that's not said in the complaint, you lose that protection. And we say that they definitely enhanced and exaggerated anything that came near to what they said in the complaint. So on that ground, a defamation count is valid.
Thank you. Thank you, Bill. PC-16 Doe versus Hill Regional.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, represent defendants and appellants in this appeal. It is the appellant's contention that the motion court erred in denying their motion to dismiss based upon lack of personal jurisdiction. The two loan arm provisions that are at issue on this appeal as 301A1 and 301A2. Both of them have an element of agency. The agency requirement is satisfied if the agent, the actor, acted for the benefit of the principal and with the knowledge and consent of the principal. Case law in New York State is well settled that when a sexual assault is committed, it is not committed in the furtherance of the employment, it is outside of the scope of the employment, and it's committed solely for personal motives of the perpetrator. As the Second Circuit earlier this year had the opportunity to apply this New York State legal precedent in the context of sexual assault case, and this case is factually analogous to the facts of this case. This is an Eduardo versus Roman Catholic Bishop of Providence, 66 F4 69. In that case, an altar boy traveled to New York with a priest, was sexually assaulted here. The Second Circuit in that case, citing New York State law, held that plaintiff's complaint failed to allege facts suggesting that the priest acted for the benefit of the church. It also held that
Or maybe, was this a school-arranged trip to sing at Carnegie Hall?
Absolutely, Your Honor. That is the allegation. We have to take them for their face value. But that brings me to my second point, the allegations
Can
that...
I just ask you, you're talking about A2 now, when you're talking about that Second Circuit case, right?
Your Honor, actually, that Second Circuit case applies to both A1 and A2 because it deals with the agency principle, and then it also, I was going to refer back to it when I'm talking about A2. Agency concept applies to both of these standards, but I do understand the plaintiff has another direct negligence supervision allegation that I will get to in just one moment. So with respect to the claims that the school did know about this trip and allowed this trip to happen, the Eduardo court has held in the reliance on this, on the legal precedent from New York State courts, is that that is not an allegation that the agent acted with consent. In other words, the request to have for the tortious act had to have been made by the principal.
Just tell me what claim are that? It's not. Are you saying that's directed towards the negligent supervision claim?
No, Your Honor. This is for any claim against the Connecticut defendant based upon their vicarious liability for the tort of the agent. I'm sorry?
Including because through a theory of agency.
Through the theory of agency, right, which has application to both
provisions.
Okay.
Got it.
So now with respect to the direct claims of negligent supervision, hire, retention against the Connecticut defendants. Despite plaintiff's claims, the legal precedent and the legislative history with respect to this CPLR provision has been always narrowly interpreted to mean that the actual defendant had to have been present in the state of New York to commit the tort. This court had occasion to consider this very issue very recently in August of this year in SOS Capital versus Recycling Paper Partners of PA LLC.
So can you focus on 302A1? Because yes, about 302A2.
Okay, so 302A1 is completely eviscerated based upon the lack of the agency. So as the Eduardo court held, because the Dunkel did not act for the benefit of the Connecticut defendant.
In that particular case, there were like private meetings that were going on. This was a school-sponsored event, right? To go sing, the school choral group to go sing at Carnegie Hall. I mean, surely you're not saying, or are you saying that that was not a school-sponsored trip? The New whatever choral group to go sing with the choral society.
Well, Your Honor, we have to assume for the purpose of the appeal that those are the allegation and was school-sponsored. However, and I quote from Eduardo, the non-resident principal must request not just the agent's general presence in New York, but also the activity given rise to injury. So that is still the distinguishing factor. So allowing the trip to take place is not the same as requesting or.
So you're saying the transaction, the transaction of business isn't connected to the suit, isn't connected to the wrong, because the wrong couldn't have been part of that person's employment obligations.
I'm saying both, absolutely. I'm saying the agency is lacking, and I'm saying the causal nexus is lacking for that very reason as well.
Why not? You're traveling to New York from Connecticut for the purposes of taking part in this choir at Carnegie Hall. So why is it not connected to the business?
Because the case on the issue of nexus requires something more than attenuated connections, or as the Eduardo court mentioned, coincidence. So, and actually, the Eduardo court language, I can quote in this case, it said, chain of causation involving physical presence in New York does not by itself create the nexus. So this is basically what happened in this case. It happened in New York because they were already in New York. There is no actual connection between the intended business and the tort. It merely coincided with it. And that's why the causal.
In Eduardo, it happened in a hotel room. Here, it happened at Carnegie Hall. So it was separate from the fundraising intent to come to New York.
Your Honor, yes, there are additional factors present in that case that aren't here, but the takeaway, again, is that the intended business must have been directly related to it, not merely coincided with it. So because this sexual assault was completely performed by this person on outside of the scope of his employment, had nothing to do with the trip, the direct nexus and the intended between that and the intended business is lacking. Thank you very much.
Sorry, it's late in the day. Good afternoon, Your Honors. Ari Taub, Phillips and Palacelli, on behalf of the respondent.
Counsel.
Yes, Your Honor.
If we removed the jurisdictional issue, this sexual assault clearly would not be a claim, well, not clearly, because you never want to speak in such absolute terms. The school might not be responsible for a sexual assault, done by a teacher, removing the jurisdictional issues. But here we have that jurisdictional issue, but that's the legal claim. And it just so happened that it happened to be here in New York. But they're not, how is that doing business? That wasn't part of doing business, as maybe they're not driving a vehicle, and then the kids get into an accident. That's something different.
Sure. So with respect to A1, which is the business transaction, case law is extremely clear that it is not about the business. It has to be related to the purpose for which you came to the state.
I have to say, the Supreme Court, like a couple of years ago, made it very clear that it is about what business are you transacting in this. But let me just ask you, first, is the plaintiff a New York resident?
He is.
And was he a New York resident at the time of?
He was not.
He was not. So
correct.
At the time of the assault, the plaintiff was not a New York resident. The defendant wasn't a New York resident. That's correct. Neither one of them had any connection to New York, except they came to New York to sing in the choir at Carnegie Hall.
That's correct.
And based on that, you're alleging long-arm jurisdiction.
No, Your Honor. Okay. What I'm alleging is that CPLR 302A2, which states that if a tort is committed in the state of New York, you have jurisdiction if the plaintiff sues here. In this case, a child was brought over to New York with someone whom the complaint alleges the defendants knew that he was a sexual predator. He came to Carnegie Hall and sexually abused my client.
The tort that are you referring to the negligent hiring, supervision?
There's two of them.
Okay.
One of them is with respect to negligent hiring, supervision, and retention. That cause of action relates to the school's duties as employer of the abuser.
That all happened in Connecticut.
Absolutely not. Your duty to control and supervise your employee involves wherever your employee is, provided that he goes there on your behalf.
Negligent hiring?
Negligent hiring, supervision, and retention of an employee. And by the way, the second department held exactly the same thing in WCVA Doe, which I cited in my brief. And if you look at that case, Your Honors,
That's not a jurisdiction case, is it?
it absolutely
Was it?
is, and
I
it's
can't remember.
302.
I've read so many now, I can't.
But I commend that decision to your attention.
Well, what do you say about the Second Circuit decision?
I was about to go there. Eduardo appears on its face as if it's the same circumstances as this, but similar to what Justice Pitt Burke had said, as well as additional issues. The most important issue is if you read the facts of that case, the decision, it has one word that you will not find in a New York jurisdiction case, and that's the word facts. In this court's decision, the court says plaintiffs alleged. In Eduardo and in federal court cases, they say plaintiffs have not alleged facts because the pleading standard is different. In federal court, you do not just allege that the defendant knew or should have known about the abuse. You need to allege, how do you know that? Because it's a different standard. So under WCVA Doe, which was a
But that doesn't have to do with the jurisdictional issue.
It absolutely does.
In what way?
Because the court has to determine whether or not, if the court reads the Eduardo decision, you'll see that first they say plaintiff alleges, and then they say, but plaintiff hasn't alleged facts to support that contention. And exactly what was being said earlier about the purpose of the transaction. This transaction was integrally related to the purpose of the trip. He took my client to New York during that trip and
To sing, right? That's the purpose of the trip.
And in that location, when they knew that he was a predator, in that very location on that trip, he was abused. And I will add one more thing. This is a 3211 motion. I haven't had any opportunity to obtain fact discovery. If it comes out that there was another person on that trip, there is no question that there's no jurisdiction. Why? Because the entire argument that's being made is you don't have jurisdiction because our client was not in the state and you can't consider the abuser himself. Well, if there was someone else on that trip, then the entire argument fails.
You mean another teacher or another supervisor?
Correct.
Oh, okay.
Right.
Not another student, right?
Not another
'Cause I'm
student.
assuming
There were other students, not
Right.
another teacher. If there's another teacher, I would pose this question to my colleague on the other side. If there was another teacher, how do you get around jurisdiction? You have a tort committed in the state, the defendant is present in the state, and the injury occurred in the state. There's no argument that circumvents
No,
that.
the defendant isn't present in the state. The school isn't present
Sure
in the
they are.
state. Its employee is present.
Which is the language of the statute.
And so what I think the argument is that this act is outside the employee's duties and therefore cannot be attributed
Justice
to the
Scarpullo,
employer.
if the defendant owes a duty in loco parentis to supervise my client, and they were in, I see my time is up. I can.
Oh, please, yeah, okay.
They have a duty to supervise my client, which, by the way, in Eduardo, they did not.
No, we're not talking
And so,
about the
right,
stuff.
so
We're
what
talking
I'm
about
saying,
302A1.
what I'm saying is this is not a vicarious liability question. The abuser is not the person, and I make this very clear in my brief, is not the basis for the liability. It is the negligence of the school for not supervising my client. It's not about the employer-employee relationship.
For not supervising your client?
It's not about my not supervising the employee. It's about not supervising, I apologize, my client. And therefore, their duty to supervise my client in New York is their own tort. And if they had another employee in New York, then there is no argument that they did not have an agent in the state of New York And as a consequence, they're subject to jurisdiction under 30.
So anytime anyone who has a duty to supervise comes to New York, you're saying that creates long-arm jurisdiction?
If they have breached that duty in New York, that's what the
Wow.
statute says.
Wow, that's all I'm saying about that.
That's what WCVA Doe held expressly, Your Honor.
Thank you.
Your Honors, I would just like to know, with respect to my opposing counsel's argument that discovery may reveal that there were other people to supervise and they failed to do that in the state, this argument is not only unpreserved, but it actually completely eviscerates the very nature of plaintiff's allegations in the complaint. The very nature of the negligent supervision claim, and now I quote from the complaint, is that the Connecticut defendants delegated the supervision of choir children, including plaintiff, to Dunkel, and permitting travel of minor children into the state without adult supervision other than Dunkel. That they asserted that Dunkel had unfettered access to minor children without any other adult supervision. They said he solely was in charge of them. So the entire nature of plaintiff's failure to supervise claim is that nobody else came with them, is that plaintiff was sent.
Well, I think that more so it's trying to, I guess, shore up the argument that they were here on a school trip, and that's the basis for the A1 jurisdiction, at least in some regard. I don't know.
But, I mean, wouldn't the plaintiff know? Isn't the plaintiff the person who would know whether there was anybody else there beside him? This person is dead, so the only person who would know is the plaintiff. And I suppose if the plaintiff knew that there were other people on the trip, the plaintiff would have pled that.
Absolutely, Your Honor, and they took the complete opposite position, which does not confer jurisdiction over my clients. Thank you very much.
Thank you. Thank you both. People v. Wilfredo Pagan.
Good evening, Your Honors. Paris DeYoung of the Legal Aid Society here on behalf of...
4:50, it's not quite evening.
I stand corrected. Good afternoon,
4:50, please, don't
almost
push it.
evening. I stand here on behalf of Appellant Mr. Wilfredo Pagan. In light of the recent enactment of the Driver's License Suspension Reform Act, which terminated all driver's license suspensions based on traffic-related debt, this court should vacate his convictions and dismiss both counts. Contrary to the people's claims here, both the express language of the statute and its legislative history...
So first we have to look at the waiver. Why is the waiver of his right to appeal deficient?
As an initial matter, we argue that the Driver's License Suspension Reform Act claim actually survives even a valid appeal waiver in light of the fact that the enactment...
Based on what?
The fact that the enactment of this act came long after my client pled, and so we could not knowingly have waived his right to relief that did not yet exist. But in any event, the appeal waiver here was plainly invalid. There are several reasons for that. The primary is that the lower court failed to describe the nature of the right to appeal, which would have included discussing the consequences of waiving such a fundamental right, as well as his right to appellate counsel. Both of those factors were simply ignored here. The lower court failed to enumerate any of the claims he was supposedly waiving, which would have included his ability to argue on appeal certain errors that would have required a modification or reversal of conviction, including the right to appeal the severity of his sentence. This court has repeatedly affirmed that discussing the specific consequences of a waiver is necessary to a valid appeal. The failure of the lower court also to discuss the right to appellate counsel was particularly important here, given my client's well-established indigency and the fact that he was represented by appointed counsel. The people in this case...
What case says that because a defendant is indigent that there's something more that has to be gone into in terms of appellate rights?
Well, no, Your Honor, we're not saying that with every indigent individual there'd be a separate requirement for the appeal waiver. We're saying it's one factor that should be considered. And
what case is there that says that that's a factor that should be considered?
Well, the model colloquy, Your Honor, is actually what I'm relying on here, which does...
So there's no case, because I thought maybe I was missing something. I didn't know of any case.
No, Your
that
Honor,
said
there is no case as of yet that
Thank you.
discusses the importance of discussing appellate counsel, but I think it can be inferred from the facts of this and the fact that the model colloquy does make clear that that's something that should be expressed to a criminal defendant.
So now let's move on to the DLSRA. Where in the DLRSA does it say that the legislative intent was that these types of convictions were subject to vacator?
Well, so the prosecution makes the argument, which I think is what Your Honor is getting at, that there is no mention of VTL 511 convictions in the language of the statute itself. But that's not dispositive here, because what the act actually did is it legalized the underlying requisite conduct for a VTL 511 conviction. So by retroactively terminating all of these license suspensions.
Well, that's the other thing. Is it retroactive, right?
Right, that is the primary question here, and there
Okay,
is
so
a
let's go to
specific-
the vacator. The legislative intent was to assist individuals in terms of their ability to pay these fines, so that they would have the ability to enter into some type of an installment plan or something of that nature.
Well, that was one piece of it, Your Honor, but actually the act terminated all license suspensions that were in effect prior to the act's enactment that had been issued on a failure to pay
Effective
basis.
a certain date. So effective, I forget what date, the commissioner would then go forward with it.
Well, yes, there was an effective date for the act, but that doesn't change the fact that all of those license suspensions, regardless of when they came into effect, were going to be retroactively
So
terminated.
the act was remedial, is that correct?
Absolutely, and the prosecution does not make any claim to the contrary. I think I won't go belabor this point. I went into it at length in the briefs, but it was meant to rectify New York's longstanding practice of criminalizing New Yorkers for being poor. That's why they were picking up these convictions in the first place.
So we're
which is
back
exactly
to the
what happened.
question is, where in the act does it state that it is for the purpose, or that you can vacate underlying convictions?
Well, Your Honor, I think it's inherent in the language of the statute. Again, it doesn't specifically reference VTL 511. We concede
Okay,
that.
where is it inherent in the statute?
So the statute, in that retroactive pronouncement where it says all driver's license suspensions that were issued on this basis have to be terminated and are no longer in effect, that legalized the underlying requisite conduct, the basis for all of these VTL 511 convictions. And the legislative memorandum talks at length about, and it discussed how criminal convictions are really the thing they're trying to avoid here.
So if the intent was to vacate all of these convictions, why did it not simply say vacate these convictions, as opposed to stating now there's going to be a process for fines and the payment of fines now and installment payments of fines?
I can't speak to why the legislature failed to be clear about that, but I would say, given the legislature's...
My point was, I'm sorry, is that not an indication that that was not the intent of the legislature? Because if that was their intent, that to vacate these convictions, they would have said that, and they would have done that, as opposed to imposing now these proceedings wherein you're talking about lessening the fines and installment payments, et cetera.
Well, respectively, Your Honor, the legislative memorandum actually went into at length the fact that the unjust consequences of these longstanding and repeated license suspensions is criminal conviction, and that is something they are wishing to avoid.
Right, so we
I
want to
think that in
avoid that,
language-
so what we're going to do is we're going to vacate these convictions, period. And that's not what they did, right?
It's not what they did, but they did make the effort, and I think this is worth emphasizing, that they did put in the statute retroactive language saying everyone is entitled to relief who had a license suspension on their record on this basis prior to the enactment of this.
Well, that's retroactive language concerning those convictions, not stating that the statute is retroactive and that therefore it would apply to your client, who I believe was convicted, I forget how many years prior to the statute.
It was about 3 years, Your Honor.
3 years. So there's nothing that says that even if your arguments are correct, there's nothing that says that they would be applicable to you based upon when your client was convicted.
That is correct, Your Honor, but what we are asserting is that the act had the practical effect of repealing VTL 511 convictions where the underlying suspension was issued on that basis, because all of those license suspensions, regardless of when they occurred, were retroactively terminated, and they did provide for that explicitly in the legislation.
Good afternoon, Your Honors, if it's still afternoon, and may it please the Court.
Hey, let me see.
Covering yourself in both ways.
Yeah, good afternoon, good evening.
So defendants...
3 minutes.
Two of defendants' 3 claims are foreclosed by his valid waiver of appeal. As the Court of Appeals has held in People v. Thomas, there's no mandatory litany, no specific language that the court must use so long as it ensures that the waiver was knowing, voluntary, and intelligent, and it was here. Moving to the retroactivity argument, essentially this argument is academic. Although the DLSRA is prospective, defendant would still be guilty of both charges based on the other non-payment related suspensions. So even assuming for the sake of argument, the defendant's suspensions for failure to pay a fine were rendered illusory, defendant's license still would have been suspended 10 times on 6 dates, and he still would have been guilty of both charges. But the DLSRA was intended to be applied prospectively. We start with the presumption that absent a clear expression of legislative intent, the statute will apply prospectively. We also do have evidence of the legislature's intent in that they delayed the effective date of the termination of those suspensions. Further, defendant has already been sentenced, and this court should not now disturb a settled outcome. And I think just to the heart of the matter, counsel's argument conflates the administrative penalty of the license suspension with the criminal conduct of driving without a license. As to the plea allocution, defendant's contention is unpreserved, but and I would note, especially here, he had ample opportunity to challenge at the trial level this plea because there was a year between the plea and the sentencing due to his repleader agreement. But in any event, it is meritless. The defendant does not need to allocute to the facts if he pleads guilty to a lesser offense. The Court of Appeals precedent is clear there. He also benefited from consultation with counsel. There's an absence of evidence of innocence or mitigation, and the court thoroughly explained his rights. Finally, I would just note that the sentence was fair and appropriate here. Defendant was charged with an e-felony, and he could have faced 1 1/3 to 4 years in prison. Instead, he was able to walk away with a fine and only misdemeanor convictions. If your honors have no questions, we would ask that you affirm.
Thank you.
Your Honors, I'd like to start by addressing the plea allocution issue. We do concede that this was an unpreserved claim, but we feel like that the interest of justice jurisdiction here would be appropriate for several reasons. The prosecution repeatedly conflates the April incident and the March incident, and that conflation is what leads to the argument that somehow my client admitting that he committed X offense on Y date somehow covers that he committed X offense on Z date. There's no case law to suggest that that's true. There's also no case law saying that there's under no circumstances do we need to conduct a factual allocution. There is some case law saying that if you've a defendant who has a very extensive criminal history, a factual allocution may not be appropriate. That was not the case here. My client had 1 prior misdemeanor on his record. It was for a similar offense, which is a low-level unclassified misdemeanor. And so here, there did need to be at least some factual allocution, some factual basis that could establish that my client committed a separate crime on March 11th than he did on the April incident. That simply did not happen here. Very briefly, I'd like to address the excessive sentence claim. I will keep it brief. It defies logic to impose more than the minimum financial penalty on an individual who's too poor to pay his traffic tickets and whose poverty is why he has the conviction in the first place.
The fine imposed is $500?
$500, yes. That was the top, that was the maximum he could have received for the 3rd degree count. I also want to note the prosecution makes the argument that he got this incredibly beneficial deal. He was actually sentenced to an illegally high sentence. Probation was not an appropriate sentence for the 3rd degree conviction that he received. It was only appropriate for the 2nd degree. There's a number of other mitigating factors here that weigh in favor of a reduction in sentence beyond just my client's indigency. One of those is that when he was arrested in the April incident, he informed the arresting officer that he was only moving his car because he could no longer afford to pay for the parking garage where he was parking and had found a safe place where he could park his car where he would no longer get those tickets.
Do you have to drive the car in order to move it?
I'm sorry?
Do you have to operate the motor vehicle in order to
Yes. And he did admit, my point more, Your Honor, is that he did admit that he was driving without a license but was trying to avoid future tickets so as to avoid future interactions with the criminal justice system.
Could you address the argument that some of those suspensions were not related to not paying the fines?
Absolutely.
That not all of them related to this new statute?
That's correct. So there were two types of license suspensions on his record. There was failure to answer summons and failure to pay traffic fines and fees. Because my client did have other license suspensions on his record for failure to answer a summons, we are asking that this court dismiss and vacate in the interest of justice. What I think is worth noting, however, is that the failure to answer summons, just like the failure to pay traffic fines and fees, are both indivorceable from one's indigency. In fact, the last draft of the DLSRA that went up to Governor Cuomo was written to retroactively terminate all license suspensions under both a failure to answer summons and a failure to pay basis. Unfortunately, in the 11th hour, Governor Cuomo struck the failure to answer summons from the legislation, but the legislature's intent, regardless, as is evidenced by the final draft, was to cover both of those.
Thank you. Thank you very much.
Thank you.
Wagner versus New York City Department of Education.
Good afternoon or evening, Your Honors. May it please the court, Jennifer Lerner on behalf of appellants. This court should reverse. Petitioner's tenure by estoppel claim is fully cognizable under Article 78, and the law is clear that petitioner may not circumvent the 4-month statute of limitation.
So why does the 4-month statute of limitation apply and not a 6-year?
Because the claim is fully cognizable in Article 78. That's how a tenure by estoppel claim has always been brought. If you look at the cases cited by the lower court, McManus, this court in Wilson, I could continue citing cases. They are all Article 78 cases. So there's no question that it's cognizable there. We have an administrative decision that's being challenged. The appropriate way to challenge that is through Article 78.
And so the decision that's being challenged is the firing, right? And the tenure by estoppel is sort of like an affirmative defense. You couldn't fire me because I am entitled to this hearing, that hearing, that hearing because I have tenure by estoppel.
Exactly. It's the discontinuance of probationary employment, and what petitioner was saying is that, no, you can't discontinue my probationary employment because I already have tenure. In order to do that, she would have had to bring an Article 78 within the 4 months' time and failed to do so.
Or if you agreed with her, you would have had to, I guess she's saying, I didn't get the hearings or whatever else I was entitled to under the collective bargaining agreement as a tenured teacher.
Right. If she were tenured, she would be entitled to notice and those things, but she was not.
Right.
And
But you do concede that no notice was given to her concern. Is that correct?
I mean, the notice that was given was termination as a probationary employee. So there's not notice and opportunity to be heard the way there would be if she had tenure already, since that is not
How long
required.
was it from that notice that she brought suit?
So we actually argue from the affirmance of it. She challenged it through administrative procedures, and that was affirmed in April 2020. The claim was not brought until April 2021.
So a year later.
So a year later.
So she's, unless there's some other statutory time, she can't.
Absolutely, Your Honor.
Okay.
Unless there are other questions, I'll leave it at that.
Thank you.
Thank you.
Good evening, Your Honors. May it please the court, Daniel Dugan for the respondent, Ms. Wagner. The Supreme Court properly applied CPLR 213 and applied the 6-year statute of limitations.
So what you're saying is I can get fired, and 5 years and 300 days later, I can bring a claim saying that I didn't get my due process under the collective bargaining agreement. I have to be reinstated, and 5 years of the salary and benefits be paid to me.
Because
you think that that's
tenure by estoppel is its own cause of action.
where? How is it? What is it? Where is
In
that?
and of itself, CPLR Article 78 is to challenge a final determination by an agency. Here, the cause of action for tenure by estoppel itself is the failure of that agency to take action.
Isn't that exact? Oh, I'm sorry. Go ahead.
We in the first department, we've actually addressed this issue in the Triana case back in 2008, and we found that, one, it's a 4-month statute of limitations under the Article 78 to bring the case. But then also there are cognizable claims under tenure by estoppel, but you still have to bring it within 4 months, right? So while we might maybe agree with you that maybe she was entitled to due process and things of that nature, that's still something that needs to be raised within 4 months. I guess the question is, when does that 4 months begin? And was she anywhere close to it?
No, you do have the COVID tolling, but no, it is not within 4 months, even after the end of the tolling suspension period. It was off by about a month. But tenure by estoppel in and of itself can be brought if there is not a termination from employment. Thus, there would have been no final determination made by the agency that would need to be brought under an Article 78 proceeding. You can bring
Isn't that the whole point? If there's no adverse action, you don't have any, you don't have a.
Well, I didn't mean to cut you off, but there would be a large benefit to enforcing your rights for a determination that you are a tenured teacher. Very big difference, a lot more protection.
But I mean, there's no adverse action that's being taken against you that would require you to have that determination.
And that's the cause of action in and of itself. It's the failure of them to act, and I want to enforce my rights.
That is exactly it. Isn't that the exactly what Article 78 is about? The failure of the government to do something they're required to do?
No, CPL Article 78, you would challenge a final determination when it becomes final and binding on me.
You could challenge I write you a letter and say, I'm entitled to tenure by estoppel. The city says, you have to have a live controversy, right?
Right.
How would it come up as?
It became live once my date passed and they failed to act.
No,
maybe
once
the
you
end
just
of my
never
probationary
decide to
period.
assert your rights. It only becomes live when you assert your rights.
No, you can bring the cause of action without telling them that you think you should be tenured. It's when they fail to act.
I agree. What you say to them is, you are required to do this, government, and you failed to do it. That's exactly what an Article 78 proceeding is.
No, it's when they give you notice of a final determination. But I do want to point out the third department actually made this exact distinction that I'm saying right now.
I think that third department case is not.
Raphael
The
versus
third
Ithaca.
department's case said that the woman teacher at the college who got an extra letter, right? A letter that created a contractual obligation could bring that claim. And the Article 78 parts of it were dismissed, right?
Correct. And they said itself that we're choosing not to convert these into an Article 78. We're going
breach of contract.
because they're not timely.
Because they're breach of contract.
Because they're not timely if we converted them. But they are timely, and we're going to proceed to the merits on a tenure by estoppel cause of action. Then it was dismissed on the merits of that. As far as timeliness, tenure by estoppel was viewed differently with the longer statute of limitations than the 4 months for an Article 78 proceeding. Thank you.
I just want to briefly address the Raphael case in the third department. I think Justice Scarpula has it exactly right. It was not a tenure by estoppel claim as exists in McManus and as we have here, where you're challenging, claiming tenure by estoppel due to operation of law. It's a little hard to tell exactly what the underlying cause of action is from the paragraph or so in the case, but it appears to be a promissory estoppel claim based on some promise of tenure, which is completely different than what we have here. Every case addressing tenure by estoppel, which is not an uncommon claim, has been brought in Article 78, and the reasons it should be addressed that way have been well recognized by the court. These are employment decisions by the government which should be addressed quickly, and there's no reason here why Article 78 does not apply. Thank you.
Thank you. Hang versus the City of New York. You may proceed.
May it please the court, Brian Ginsberg of Harris Beach for the city. Supreme Court misunderstood the city's litigation conduct here as law office failure sanctionable under the Gordonier line of cases, but actually it was a measured, reasonable litigation strategy. Before this court's 2021 ruling, it was reasonable for the city, in the interest of efficiency, to defer moving on plaintiff's negligent hiring and retention claim and to plan instead to file a single motion for summary judgment, raising all defenses as to all claims, including factual defenses. In the interim, and again before this court's 2021 decision, it was also reasonable for the city to object to discovery of Officer Longo's personnel records as irrelevant. The Court of Appeals in the Allen case and this court in the Horn case had held that evidence is relevant if, quote, it will assist in preparation for trial. And the city correctly recognized that plaintiff's negligent hiring and retention claim stood no reasonable possibility of making it that far.
Well, see, Supreme Court said that you should have known from almost the beginning that the negligent hiring and retention claims failed. And your failure to note this and to recognize this and to therefore plead it resulted in years of litigation and a waste of judicial resources, and a colossal blunder and a waste of judicial resources.
That is what the court noted, what the court said. But as I just got done discussing with your honors, this was no blunder. This was a calculated litigation strategy in order to serve the New York State policy against piecemeal, fragmentary litigation. And that policy, there's no evidence in the record supporting any sort of lapse or law office failure on the city's part. Plaintiff has the burden of proof here in terms of providing evidence supporting that characterization of the city's litigation conduct. There just is no evidence supporting that. It's entirely consistent with this court's policy, with the New York State policy against fragmentary litigation. And as far as the litigation that ensued with respect to Officer Longo's records, again, the city acted reasonably before this court issued its 2021 decision and clarified the law. The city relied on prior pronouncements of the Court of Appeals and this court in the Horn case that evidence is not relevant if the claim for which it's asserted stands no reasonable chance of making it to trial. And again, that's exactly what the case was here. The Supreme Court found that the claim suffered from patently obvious defects, which we did recognize. We strategically, in the name of efficiency, decided to try to move on that later. But it was plaintiff, of course, who injected that claim into things. I do want to go to the rest of the elements, though, under Gordonier, because before you get to evaluating whether there's an abuse of discretion, you have to find authorization. And the Gordonier line of cases, which is the only authority on which Supreme Court relied, requires a predicate violation of the CPLR or court order. And here, Supreme Court did not find that the city did anything unlawful. The court did not find that the city took any litigation step that it was not privileged to take, either under the terms of the various discovery orders themselves or by stays invoked by operation of law under the CPLR. But if you do get past the authorization issue, which I think itself is sufficient for reversal here, there's no need to go to the abuse of discretion. If you get there, though, this was a plain abuse of discretion by the lower court in exercising whatever sanctioning authority it might have had. Again, plaintiff is the one who injected this frivolous claim into the lawsuit, and Supreme Court's premise that claim is the culprit for this protracted discovery litigation is demonstrably false. There is no dispute, we argued it in our brief and the other side didn't dispute it, that plaintiff would have pursued Officer Longo's records even if the negligent hiring and retention claim had been promptly dismissed, because plaintiff expressed the view, we don't think there's any merit to it, but this was plaintiff's position, that those records were equally relevant to the GML 205E claim, which still remains in the case. So the premise that there was this waste of time caused by the city's treatment of the negligent hiring claim, even if you get to that granular level of review, which I submit you can reverse well before that, that stated premise is simply wrong. That litigation would have ensued no matter what, and we know that because of plaintiffs' arguments in the briefs and the underlying litigation. And I'll reserve the remainder of my time.
Thank you.
Good afternoon, Your Honors. May it please the Court, this is Carolyn Canzanieri of Decolator Cohen DePrisco, representing the plaintiff respondent, Mr. Zhang. The defendant appellant here has no right to appeal a sua sponte order for sanctions, and he admits so in his own papers at page 22 of his appellate brief. He never moved for a leave to appeal. I cited Scholes versus Meir concerning that. So first, I would say that he has no right to appeal or argue this matter. Secondly, the lower court decision was correct in granting sanctions. As the court pointed out, they said there was a colossal blunder, a waste of judicial resources, a lack of due diligence, and it was only until this very court told counsel for the city that they should have moved to dismiss the negligent hiring claim did they then go back to the Supreme Court, asked for an extension of time to produce police officer Longo's records for 45 days to give them enough time to make a motion to dismiss instead of producing the records. The lower court, knowing this case for 7 years, knew that they then used that time frame just to bring the motion to dismiss, which they misled the court. It is then on the court's own volition that they did grant sanctions in this case. I had cross-moved to strike their answer, and in response to that, the court granted the sanctions, told us to submit an affirmation of legal services and fees, and that's what we did. And upon review of that and the opposition and memo of law of the defendant is when we were granted the sanctions. But there is case law that the fees can be given by the lower court upon their own knowledge and independent judgment, and that's Jordan versus Freeman. The defendant's arguments concerning why they failed to move for 7 years do not have merit in this case. They talk about the patrol guide, which is not a predicate for 205E. We never claimed it. It's not a legal basis for a 205E claim at all. They also didn't wait for discovery because they owed us the discovery, which we litigated for 7 years, 5 of which were all on police officer Longo's records, which we brought numerous motions and which even became part of an appeal. It is therefore we ask that, one, that this appeal be dismissed outright, and secondly, if not, that it be affirmed because the court had authority on their own to grant the sanctions in this case. And I would like to also just point out that the defendant does argue that we should have written in the papers to the court how many years experience each of the attorneys had in our office. That's not what the court ordered in this case. They stated to write the attorney's fees and expenses in an affirmation, which we did. And secondly, as the court oversaw this case for 7 years straight, they knew that the papers were written by Joseph Decolator, Dominic DePrisco, who both have over 40 years experience. The court was aware that there was several papers that I wrote. I have over 21 years experience. So the court was well aware of the fact that there was partners that wrote these papers, and the majority of them. Those were all on e-filing, and the court was well aware of who argued and wrote the papers in this case. And unless the court has any questions for me, I'll rest on my papers.
I was just wondering about notice and the opportunity to be heard with regard to the sanction.
Yes, the court did write in there that we had to prepare an affirmation, which we did. Defendant City prepared opposition and submitted a memo of law in response, and the court stated that if necessary, they would have a hearing on this issue. After they reviewed and were aware of all the litigation, reviewed all the affirmations, opposition, and memo of law, is when they did grant the sanctions against the city.
Thank you.
Thank you.
Thank you.
Thank you.
Just a few points in rebuttal, Your Honors. As far as appealability, I'll refer to my reply brief at pages 29 to 31. I think it sums up all the issues that my friend on the other side dealt with today. She alleges again that we misled the court somehow about extensions of time. There was no record citation to that effect here today. There were none with respect to that allegation as it was presented in her brief as well. On the fee issue, though, if the court gets this far, and again, we submit there is no reason to, but it was an abuse of discretion for Supreme Court to order the sanction at the amount that it was ordered, if nothing else. The February 2023 order, which set the dollar amount, is entirely unreasoned, and that in itself is reversible error for the cases that we cited at pages 53 of our opening brief. But in any event, even if one were to try to dig into this record and reverse engineer some sort of reasonable explanation, you'd come up empty because there's no evidence in the record that, among many other things, the $450 per hour rate that plaintiff claimed compensation at was reasonable, because there's no evidence in this record of prevailing market rate whatsoever. There's also no evidence, notwithstanding the extra record evidence that my friend on the other side just presented to you, about attorney seniority, experience, and expertise. And that is needed in order to determine the other lodestar factor, the reasonableness of the hours expended. Because we don't know who did what and what level of experience they had, there's no way for a court to intelligently review whether those hours were completed, whether those tasks were completed efficiently, given the skill level of whichever attorney or attorneys participated in them. So we think there's simply no authority for the sanction at the get-go, and that in itself requires reversal. Gordonier, which is the only authority that the Supreme Court relied on, just is a total mismatch here. But even if you find authority, there is still an abuse of that authority, an abuse of discretion, for all the reasons I've detailed here today and in the brief. So we respectfully request that the sanctions below be reversed.
Thank you. Thank you both.